start with a Kahoot. Y'all want a Kahoot? Just out the gate. Let's get going. Yay. So y'all grab your phones. I'll get you a QR code as I get myself set up. This Kahoot is our agency Kahoot. So this Kahoot is going to be on unit 7 and 8. So there we go. There's your QR. I love this. So we got our spooky agency Kahoot. There's your QR code if you want to scan that. If you're going to the website or the app, you need a game pin. The game pin for this one is 2719220. It really is the little things in life. A foreclosure. Interesting. Interesting. And look at you guys decorating for Halloween as well. Agency is fun. Awesome. I got Ghosty, the little ghost. Give you just a few more seconds if you want to play. Of course, if you don't want to play, you don't have to. But if you don't want to play on your phone, I do suggest that you play in your mind so you can gauge how you're doing. See if there's any areas you need to go back and review. Your Kahoot's not working? Strange. For some reason, if it's not working, again, you can always just play. You know if you got it right or wrong. That's the important thing to me. Kahooting's fun, don't get me wrong. But the important thing to me is that you guys know, help you focus on what to focus on. Okay, y'all ready? Somebody's phone, a couple of your phones might have went to sleep. So y'all wake those up. All right, let's see what we got. Let's Kahoot. Question number 1. Unit 7 and 8. A broker is permitted to represent both the seller and the buyer in the same transaction when ten seconds. Broker is permitted to represent both. Look at you guys go. What do we know about dual agency? If nothing else, what do we know? In order to do dual, we have to have informed written consent by both parties. This isn't my decision. It's not what's best for me. It's not what's best for the firm. We have to have informed written consent by both parties. Questions on this one? Dual agency, intentionally created with informed written consent. You guys got that running through your brains at night when you're trying to sleep? Intentionally created. No, okay, that's good if you did. All right, so let's see who got it right the fastest. Valerie answered fastest, followed by Nicolette and Ghosty. Shaq and Aubrey out the gate. Question number 2, which of the following is not a material fact? Ten seconds. Which is not a material fact? Let's all turn to page 143 real quick. Let's make sure we're good on this. So on page 143, at the top there, we have the things that are considered a material fact. So if there's a leak around the flashing of the chimney, the flashing is just what seals the hole of the chimney coming out through the roof. So if you have a leak in that, you have a leak in the roof, that would absolutely be a material fact. A cracked heat exchange in the heating system, indication that the heating system may not be working properly. So that would be a fact about the property itself. If we plan to widen the road in front of the property, that would be a fact, that second bullet point related directly to the property. It's not about the property itself, but if you are going to widen the road, it could result in the homeowner losing some front footage there. So what we were looking for, and this one's tricky, I know, but this gets a conversation going. This gets us thinking. Polybutylene pipes that have never leaked. Page 143, please know, it's not polybutylene pipes, just the fact that they're in the home isn't a material fact. They become a material fact once they have leaked and they've had to been replaced. That's when they become that material fact. So the fact that they're there, don't have to worry about it. Only need to be concerned once they've leaked. Everybody see that? You also got, we talked about EFIS, synthetic stucco. We talked about meth homes. Questions on this one? So we got Shaq climbed up the top. Nicolette, Valerie's still on. Rach and Lee climbed up. Question number 3, which of the following is true? Five seconds. Let's look on page 149. In 149, we talk about the different classifications of agency. First off, you guys, the purple unicorn, the thing that we are not going to see is the universal agent. Would you give full power of attorney to Keller Williams? Would you let Keller Williams control your finances and your medical decisions? Would you do that? I hope you're shaking your head no. Would you trust Coldwell Banker to make full informed decisions on your behalf? See, guys, that's why it's not allowed. Universal isn't allowed in an agency relationship, because remember, the agency relationship is between the client and who? The client and the firm. So universal agent is our purple unicorn. We're not going to see it. General agent is the relationship in which the broker has some power. They have some responsibility. They have some authority. A couple examples in a general agent is the relationship between the property manager and the owner of the property. We'll get into property management in Unit 12. The other example of the general agent is your relationship with your firm. You have some ability as an agent of your firm. What's that ability and how much? Well, that's up to your firm. But for example, you guys will be able to sign the agency agreements on behalf of your firm. Why can you sign an agency agreement on behalf of your firm? Because you're a general agent. You have some ability, some power. You may also be able to negotiate your commission as another example. How negotiable and how much? Well, that depends on your firm's policy. And then the third category we have there is the special agent. The special agent has zero power, zero ability to bind. And this is our relationship as a sales agent. So if you're working with buyer or a seller, may it be residential or commercial, sales is sales. So when we are working with buyers and sellers as a sales agent, we are acting as a special agent in which I don't have the power to bind. I don't have the ability. What questions do I have on this? Okay. So we got Valerie came back up. Lee's climbed up on fire this round. That's fun. Shaq's still on. Nicolette and Rach. Question number 4. Working with real estate agent disclosure must be given. Three seconds. Working with real estate agent must be given to all consumers in sales transactions. What's wrong with the mustard color one? Do we give the disclosure in all real estate transactions? That teeny tiny word means a whole lot, don't we? An example of a real estate transaction that we don't have to give the disclosure is a lease transaction. If you're working with a landlord or a tenant, the disclosure is not required. We only have to do our disclosure when we're working with buyers and sellers, residential and commercial. And we have a duty to provide that to all buyers no later than first substantial contact. The difference in first substantial contact and initial contact, if it's substantial, I'm learning something about the consumer that may impact them or affect them in this transaction. That's what I mean by substantial. Just because you tell me your name doesn't mean I know anything about your price, term, or motive. That's that first substantial contact, PTM. Questions on this one? One word changes the meaning of the whole question, doesn't it? Isn't that amazing? All is about the smallest word in our, but it's a big one, isn't it? That word all. You guys remember your absolute words. All, must, always, never. Those have meaning. Questions? Good morning. So we got Valerie staying on top. Rach climbed up. Lee's still on. Haley and Jack climbed up. Fifi's our highest climber, up 15 places this round, or 14 places this round. So good job there. Question number 5, a listing agreement may be terminated for any of the following reasons, except. Ten seconds. The different ways to terminate agency. Here we go. Good job. If the agent's license goes on inactive status, if the listing agent or the individual agent loses their license, it goes inactive, they pass away. Remember, it's the firm's listing. So the show will go on. The only exception to that rule, you guys, is if the firm is a sole practitioner. How many people are in a sole practitioner? Just one. A sole practitioner is a one-man firm. So if that man passes away, the firm has resolved. Does that make sense? If that man's firm license goes inactive, that will terminate. All these others will terminate a listing agreement. Questions on this one? So we got Valerie and Rach staying up. Haley's creeping up. Jack, Lee, Immaculate's up six places this round, our highest climber. Good job. The provision in a listing agreement that may obligate the seller to pay commission after the expiration date is ten seconds. Let's look at page 218. So there's a provision in our agreement known as the protection period, also known as the extender clause, also known as the override clause. Everybody see that? 3 different words mean the same thing. What these things do, override clause, extender clause, or protection agreement. If your listing expires, if a buyer comes forward to make an offer within X amount of days of your listing expiring, the firm may be entitled to still collect commission. And there are 2 caveats to this protection period or override clause. The first one is that we have to provide the names of the buyers to the seller. So it's not just any buyer. It's a buyer that we know is interested. So if our listing agreement's expiring today, it's up at 11:59 p.m. tonight, and we know there's an interested buyer. Maybe they're writing the offer, maybe they're considering it, but we know they're interested. We've had a conversation with them or their buyer. We provide the names of those buyers to the seller, and if that buyer brings an offer within X amount of days, that X amount of days is negotiable, then we are still entitled to a commission. The second caveat of this, if our listing agreement expires today and the seller lists with a new firm tomorrow, they have a current listing agreement tomorrow and we don't get anything. Once they list with a new firm, that relationship has been created. What questions do I have on this one? Okay. Valerie's staying on top. Haley climbed up. Rach is still on. Nicolette's back up. Bill is on. Sam I Am is our highest climber, up 8 places this round. And our last one for the day, all the following are typical provisions of a listing agreement, except ten seconds. What do we find in a listing agreement? Everything but our responsibility to the buyer. The listing agreement is between the firm and who? The firm and the seller. So it's going to spell out our duties and responsibilities that the firm owes the seller and that the seller owes the firm. This concerns me a little bit. So let's stop and have a conversation about this. A listing agreement is an employment contract. And in an employment contract, you've got to talk about how you're going to be paid once you do the job that you've been hired to do. You've been hired to do a job. Shake your head one way or another. When you do the job, do you expect to be paid? You're hired. You think you should get paid? Yeah? Yeah? What do you guys think? Shake your head one way or another. Of course. Is it automatic that we get paid? Can we just trust that the seller is going to cut us a check after closing and say, here you go, thanks for all your hard work? Absolutely not. How do we ensure that we've gotten paid? We have our listing agreement, which is our employment contract, which discusses our commission, discusses our compensation. Questions? All of our agency agreements talk about commission. Listing agreement, buyer's agency agreement, and our property management agreement. If y'all want to get paid, we got to discuss compensation. Questions? Okay. So our third place, spooky winner, Valerie. Our second place is Rach. And our first place is Haley. Crept up out of nowhere. Runners up are Bill and Ashley. Questions? Comments? Okay. I do have an announcement. We revised your tentative schedule this weekend. I have the new one in Learn Test Pass for you guys. And we revised it to include another cram course. So the date you guys always had is on November 11th. I am also doing one on Saturday, November 12th. So we decided, why not open up both of them and let you guys have choices. You're welcome to come to both. You can pick one. You don't have to come to any. Both of these are completely up to you. Jane's doing the one on the 11th. I do think sometimes it helps to hear the material from somebody else. But if you're not available on the 11th, then you have mine. It's going to be on November 12th. You guys already have my Zoom link. So if you want to come on the 12th, you just use the same link that we use to access class. We will send you all Jane's Zoom link on like the 9th or the 10th. Right? So we will send you an email with that link, but we'll do it closer to time. I do record my cram courses. So I will put, after the 12th, I will put my cram course in our YouTube channel. So if you can't attend or if you want to review it, you have that. Jane has recorded a cram course. If we look and Learn Test Pass, the whole way at the bottom, the very last thing is called cram, and you can see there's a cram class recording. So that's a recording to a cram course that Jane did. I think it was like back in March. But I think if you can be on Zoom, I think that's better. Question comes in, are these in person? Nope, they are both via Zoom. So again, you guys have my Zoom link. If you want to come on the 12th, you already have that. We will email you Jane's Zoom link on like the 9th or 10th. So just a couple options for you guys, some possibilities. Again, come to one, come to both, come to neither. It's entirely up to you. You cannot use cram course time to make up class time. Cram course is not a real estate commission required activity. This is just something that Carolina School of Real Estate offers you. While I'm here, you guys, please don't forget the 17th, our last day of class. That's our final exam. We're hovering over just over a month. We'll hit the halfway point like today or Thursday. And then please, if you don't already, have this retake date in your calendar. So if you don't pass the final exam, but you make at least a 50%, you are eligible for the retake on Monday, the 21st. And we will send information out after the exam on the 17th.
Julie.
Yes.
After we take this exam, now this is the one that we have to take in order to be able to take the national, right?
Yes.
Okay, and then once we pass this, is it like a 2-week time? I mean, do we have to, what is that process?
We are going to talk about your application and your state exam once we get through Unit 10. So hang on to that question. We're going to show you guys where you submit your application, how you can get that started, what the process is. We'll have a whole discussion on that. Other questions about our class dates? And guys, remember too, that the other thing the tentative schedule gives us is the order that we're going. So you notice once we get out of Unit 10, there is really no order. We're just kind of jumping all around because I go and order the syllabus. I don't go and order the textbook. So for those of you that are looking ahead, please remember, especially after Unit 10, to look at the tentative schedule. So you're looking ahead at what we're going to talk about next. Questions? And this is our last week till 2. So after this week, we go back to 9 to 1. Is the scoring on the final, both my test and the state exam, is as soon as you hit submit, it tells you right then, pass or fail. You don't have to wait anymore. Yeah, it's that fast. You hit submit and it says, are you sure? And you say yes, and boom, there you go. You talk to some agents that have been around for a while, they had to do a paper test and mail it in and wait for the commission to mail them back their response, and talk about bombarding your postal man every time, or your postal person every time they came by. Do you have my results? Do you have my results? Technology has changed.
You really had to do that?
I didn't. I'm not that old, but yeah, there are some agents out there old enough that had to make our very own Lane. She's been around so long. She talks about it every once in a while. I had to wait for my results to be mailed to me. This idea of automatically knowing just blows her mind. Does it let you review your answers before you hit submit? Absolutely. You guys, please remember that email you guys have from Lane. My exam is delivered on a program called Class Marker. And what we have in that email from Lane is a tutorial on how Class Marker works, what it looks like. So if you haven't had a chance, if you're not sure what to expect with Class Marker, I encourage you guys to watch this little tutorial so you can see all the things. And of course, we will have a conversation about it right before my test. The last thing we do in this class together before the test is the rules and expectations of my exam. So we will all be on the same page on how my exam is delivered, what it looks like, what to expect, all that good stuff. Yes, I just saw a hand. I'm sorry, I didn't see who it was. Let me go to my other screen.
I'm sorry, I was just making
Hey.
sure that you got me checked in. I had some technical difficulties this morning.
Absolutely.
Thank you, ma'am.
Okay, like I said, once we get through Unit 10, we're going to talk about your state exam. Some of you may want to start doing your application. Some of you may want to start that process. It's too early to talk about it until we get about halfway through, because it is a process. So that's why I choose to do it at what I consider the halfway point after Unit 10. So we probably won't see it today, but we will get to it on Thursday. I know we're not going to see it today, but we will get to it on Thursday. Does the state exam let you know after each, I wanted to wait and talk about this, but on the state exam, does it let you know after each question if you got it right or not right after submitting? No, you submit the whole exam and it comes back with right or wrong. So can we, look, guys, let's gather all your questions for your state exam and then we'll talk about them next class. Is that fair? Okay. Thank you. Good morning. Okay. So let's get back to the material. And we are in the throes of Unit 9. We will get through Unit 9 today. We'll get started on 10. We'll get a good chunk of the way through 10. I don't expect to get it finished today, though. So wherever we leave off today, we'll pick back up on Thursday. We'll do your state exam application conversation. And then we'll get started on Unit 14 on Thursday as well. So we'll talk more about that before we leave today. So where we left each other on Thursday, we were talking about performance of a contract. And I'm on page 259. And all we're talking about are just some terms, some words that you may encounter in a contract. So we need to know what these words mean. So we talked about time is of the essence. Time is of the essence is a drop dead date and time. What time is of the essence says is that something needs to be complete. Something needs to happen by this date, this time. Failure to have this complete could be an out for the party. When we look at our contract in Unit 10, we're going to see that we actually have two time is of the essences in our standard sales contract. So we're just defining the word now. We will see it in practice when we get to Unit 10 and look at our contract. The other thing that we defined before we left on Thursday was an assignment. With an assignment, the assignor, the giver of the assignment, is transferring their rights and their duties to the assignee. The or is the giver, the e is the receivee. In an assignment, the terms are going to stay the same. The only thing that changes is going to be the names of one of the parties. That party is transferring their rights. Whether or not a contract can be assigned, whether or not a contract can be assigned, has to be spelled out in the contract. This contract is assignable. This contract is not. Again, we'll see this verbiage in our sales contract when we look at it in Unit 10. The other thing we may counter is a novation. Novation in Latin, novation sometimes means new. I think that's a Latin word. Is that right? Do I have any Latin people on here? I see some heads shaking. Okay, good. So if you're doing a novation, in a sense, you're creating a new contract. You're creating a new contract to replace the existing one. Let's talk about a couple examples of when we might do a novation. Buyer and seller are negotiating the offer, and they're negotiating it old school on paper. So you have an offer, buyer makes an offer, and the seller says, I'm not good with this purchase price. So the seller strikes through the purchase price, writes in the price that they find acceptable, and everybody initial and dates it. Once you do that enough times, when we look at our contract, we're going to see, I don't have a lot of room to write. We have very tight margins. We have very little white space. So we don't have a lot of room to write. So once you make a change enough times on our contract, it gets hard to read. So once we come to terms, once we come to agreement, the suggestion is that you do a novation. You go through and you do a brand new clean contract with all the agreed upon terms to substitute, to replace the contract that we can't read because we had too many changes.
I have a question.
Yeah.
So in saying, excuse me, so in saying that, if you've already been doing a contract and everything, this is prior to signing it?
We're
Or
negotiating the offer. That's correct. We're
this is in a
negotiating the,
negotiation? Okay,
that's right. So once we come to terms, we've agreed, a contract's been formed, but now we need something we can read. So that's where the suggestion is. Let's get everybody to sign a nice, new, neat contract. You guys do your head one way or another. Are you going to keep the original contract with all the changes and the strike throughs and the initials and the dates? Are you going to keep that? Let's shake our head yes. Because what do we document? Everything. Don't throw it away. That old contract with all the changes and the initials and the dates, that old offer / contract, that shows the meeting of the minds. That shows the parties coming together and agreeing to the contract. So are we going to keep it? Yes. Keep everything, document everything. I'll share this with you guys. Once you guys get into, your firm will have some kind of electronic program, maybe that be .loop or DocuSign or SkySlope, right? We have some kind of e-program with e-signatures. And my firm, for example, uses .loop. And .loop was designed to not let you delete anything. Once you put it in there, you can't get rid of it. You can archive it, you can hide it, but you can't delete it. And guys, that's not designed by accident. That is designed to keep us honest. Don't delete anything. Don't throw things away. Document everything. Another example of a novation, I actually had a personal experience a couple years ago with a novation, and I was so excited because I was like, yay, now I got a story in pre-licensing. So I was the listing agent. The seller was an investor. So they bought the property, flipped it, put it back on the market for sale. So we listed the property once he got it done. We had a buyer come forward, make an offer, and the buyer was using an FHA loan. I'll talk about the different loan types when we get to units 14 and 15. So hang on to that for now. They were using an FHA loan. I did not know, nor did the buyer's agent. It was a learning experience for all of us. We did not know that there's a requirement with an FHA loan that the seller has to have owned the property for 90 days before they can convey it. Y'all, the day we went under contract, my seller had owned that property for 89 days. Goodness, we were close. And the lender called and said, underwriting will kick this out. So what did we do? Everybody sat still. We were patient on day 89. On day 90, we did a novation. We substituted a new contract with the date that would make underwriting happy. What if it's new construction? Is, to my understanding, all FHA loans require the seller to own the property for at least 90 days. So how did we satisfy underwriting? We did a novation, and we all learned a valuable lesson that day. And guess what? I just shared with you. So hopefully you guys won't make that same mistake. I just gave you some information to help you in the real world. All we need to know about a novation, though, was for whatever reason, pick a reason, we're going to substitute a new contract for the old. Let's see. I had a question come in, but I'm not clear. Can we talk on break or outside of class, or maybe give me some clarity? I'm not, but I do want to address your question, but I don't feel like that's on topic. So let's talk about this. Okay. Another word. Oh man, I meant to ask you guys that. What did we learn about an amendment back in Unit 6? What's an amendment? I can see y'all's mouths move. An amendment is just a change. Man, I dropped the ball on that one. If you're amending something, you're making a change. We talked about a zoning amendment. Why am I getting some blank looks? Y'all remember talking about a zoning amendment? A zoning amendment is a change in what? Change in the zoning. So if we're amending the contract, we're making a change to an already existing contract. We've already come to terms, we've already agreed, signed, we have a contract in place. For whatever reason, we've entered into round 2 of negotiations. And at the end of round 2 of negotiations, maybe we have a newly agreed upon purchase price. Maybe we have a newly agreed upon closing date. We have changed something that we already agreed to. I would like you guys to compare an amendment to an addenda. When you guys see the word addenda or addendum, do we see the word add? An addenda adds to and becomes part of the offer or the contract. It attaches to it. It becomes part of the negotiated. Once we get into Unit 10, we're going to talk more about our forms. So we'll talk about an amendment. We'll talk about an addenda. We already looked at one addenda. You guys remember when we looked at our lead-based paint hazard addenda? That was an addenda. That was something that added to and became part of the contract. So let's talk about how contracts end, discharge of contracts, how they end. Please note we're talking about contracts. The contract has been formed. We're no longer negotiating an offer. We talked briefly about how contracts are formed. We're going to get more involved in that today. There's several different ways that contracts can end. What I need you guys to see from this slide, there's a whole bunch of words on here. I don't think you need to know these words. What I think you guys need to see from this slide is the agreement of the parties. If the parties agree to enter into a contract together, can't the parties agree to get out of a contract together? There's our mutual agreement again. So if, for example, buyer and seller decide this isn't working, we need to get out of this, then we have an agreement of the parties. They agree to terminate the contract. This just gives us some example. They can release each other. They could do a novation. They could substitute one contract, a new contract for the existing ones. They could modify their agreement. Accord and satisfaction, that's just partial performance. Maybe I promised you I was going to leave you Whirlpool appliances, but Whirlpool is on back order and I don't have time to get them in. So would you be okay with partial agreement if I give you Samsung appliances? It's a partial agreement. It's not the same thing that we agreed to. The old school way of doing it, before we had like fancy computers and internet and e-documents and everything, the old school way of doing it was actually taking the physical contract and a pen and writing cancel across it. Pretty clear that the parties have canceled the contract. Again, what I need you guys to see from this slide, the parties have agreed, they agree to enter into the contract together. Can't they agree to get out of it? That's one way that can end, one way that can terminate a contract. Other ways that can terminate a contract, full performance. Once the responsibilities and obligations and duties of the contract have been fulfilled, the contract is no more. Talking about our sales contract. The whole gist of our sales contract, the buyer agrees to buy, the seller agrees to sell. Now, when we get into Unit 10, we look at our contract, we're going to see that it takes us 16 pages to say that. But the short and sweet of it, the buyer agrees to buy and the seller agrees to sell. So once the buyer is bought and the seller is sold, haven't they done what they promised to do? That's our full performance. That gets us out of the contract by, for example, going to closing. A contract can end if it's impossible for either party to perform. Let's say, for example, we find out once we go under contract that your buyer's not going to get loan approval. We'll talk about that process, pre-approval, pre-qualification. Guys, those are not guarantees. It's a pre-approval. It's a pre-qualification. We'll talk about that process when we get into units 14 and 15. But if we find out your buyer doesn't qualify for the loan, unless they got a mattress stuffed full of cash somewhere, it's impossible for them to buy. They got to have the cash. So no loan approval would be impossibility to perform. Mutual agreement, again, we can agree to get out of it, pretty much saying the same thing we just said. Operation of law could end a contract. If the court takes the property for any reason, foreclosure, bankruptcy, eminent domain, if the court takes the property for any reason while we are under contract, it's no longer the seller's to sell. Thus, we do not have a contract anymore. And then lastly, breach of the contract by either party. One thing we will see when we look at our contract, our sales contract, there are remedies for the buyer if the seller breaches. There are remedies for the seller if the buyer breaches. It's one thing that a legally binding contract is going to address is what happens if either party doesn't do what they promised to do. And that's what we mean by a breach. So it's got to spell out those consequences. The book on page 261 gives us some general rules for how a court will interpret contracts. Now you got more in your book, which is why I like you guys to make a note on 261 to look at all those bullet points there. We're just going to pull a couple out. When the judge has a contract in their hand, they're using these general rules. The judge is going to interpret the contract as a whole. They're not going to break it up into pieces or sections. It's all or nothing when it comes to contract. They're going to interpret it as a whole. Words will be interpreted per their ordinary meaning. Guys, we as real estate agents are completing these sales contracts on behalf of our buyer or seller. And as you guys are learning in real estate, we have our own language. Once you learn to speak broker, which you guys are working on it, my industry's jargon, my industry language does not belong in the contract for the buyer and the seller. In other words, they need to be able to look at that contract and know what it means. They need to be able to look at it and know what that is. So we need to put normal words in there, not broker speak. So anything that's not of its ordinary meaning, anything that's ambiguous is going to be judged against the party that prepared it. Don't use acronyms in contracts. Goodness, we are an industry of acronyms. If we can make an acronym out of it, we're going to. That doesn't belong in the contract. It's so important that we remember that we're preparing these for people that don't have a license, that aren't brokers, that don't speak our language. Do I have everybody? So we need to make sure we're putting them in words that they can understand. If not, then the judge will rule on the party that prepared it. Okay. There's also some contract remedies in basic contract law. The first set of contract remedies is money damages. So everything we're looking at this slide is money damages. Compensatory damages, usually the non-breaching party will have to sue. And what compensatory damages are, what their point is, the non-breaching party is trying to get the breaching party to make themselves whole again. What kind of money, what money did you spend as a result of this contract? If you're suing somebody for compensatory damages, you're trying to get reimbursed for the money that you spent. When it comes to compensatory damages, you guys write down, please write down invoices and receipts. With compensatory damages, you can prove that you spent this money in relation to this contract. How do you prove it? Invoices and receipts. So let's say, for example, you're the buyer and the seller breaches. The buyer could go after the seller if they've already spent money on, for example, a home inspection, an appraisal, a survey. Aren't those things that the buyer spent money on as a result of this contract? And if the seller breaches, doesn't the buyer have the right to get that money back? Possibly. They could go after the seller for compensatory damages. It's not meant to cover pain and suffering. It's just meant to cover the actual amount of damage. I'll come back to liquidated damages in a second. Consequential damages, again, are money damages. The non-breaching party may have to sue, but these are special damages. These are things that have occurred because of some foreseen contractual obligation. It goes above and beyond the contract itself. Let's say, for example, you breach our contract and I have to take you to court. In addition to my compensatory damages for me to get my money back, I could also go for consequential damages, which are my attorney's fees, court costs, things like that. I think another good example of consequential damages, when we look at our contract, we're going to see that the buyer is responsible for any damage to the property caused by anybody they hire. So if the home inspector damages the property, the buyer's on the hook for that. And if that buyer's not willing to pay, the seller could go after them for consequential damages. We'll see that verbiage in our contract. Compensatory and consequential, usually the non-breaching party has to sue, not unless they're willing to sit down and write a check. If they're not willing to sit down and write a check, we need to sue. Liquidated damages are also money damages. They're a little bit different though. Liquidated damages, we agree to these amounts as part of contract formation. The contract says, if you breach, I get X amount. And that X amount is negotiable. We agree to that when we're forming the contract. We usually shouldn't have to sue the non-breaching party because they already agreed to pay these liquidated damages. Now, if you're not willing to sit down and write a check, then yeah, you got to take them to court. When we look at our contract, we are going to see that liquidated damages are awarded to the seller in the event of the buyer's breach. The buyer puts down a deposit and a fee that we will talk about. And if the buyer breaches, the seller knows how much they're going to be awarded. They know what their liquidated damages are because we've agreed to those negotiable amounts. So our money damages in the event of a breach. Another contract remedy in event of breach is something called specific performance. And with specific performance, the non-breaching party is suing the breaching party. And what they're hoping is that the judge will make the breaching party perform as promised. Where we may see specific performance, the buyer sues the breaching seller. The buyer goes after the breaching seller for specific performance. And if the judge awards it, they can make the seller sell. The buyer can go after the seller to make them perform. I have never in all my years heard of a scenario where the seller can go after the buyer for specific performance. Now, I'm not an attorney, so I'm not going to stand here and swear to it or anything, but generally where we see it, the buyer sues the seller to make them perform. And in our sales contract, again, the seller's performance is to sell. The other contract remedy we have is a rescission, to rescind the contract. Some contracts have a built-in, if you rescind your contract, you take back your contract. If you put down any deposits, you get your money back. Both parties go about their lives as if this contract never happened. So a rescission is to rescind, take your contract back, get your deposits back, and walk away. In a private chat, let's test your memory. In a private chat, who remembers how many days the buyer has to rescind their timeshare contract? How many days does the buyer have to rescind their timeshare contract? I didn't give you guys time to hit private chat. What do we remember about timeshares? Y'all guys want to do it together? 5, 5, 5, 10, jazz hands. So how many days does the buyer have to rescind? Let's venture out and say it's one of those 5s. Here's another question for you. How many days does the buyer have to rescind their contract for a new construction condominium? There it is. How many days does the buyer have to rescind their contract for a new construction condominium? And in that one, we're looking for 7 days. So 5 for a timeshare, 7 for a condo, new construction. Again, all we're saying is the buyer has this recession period. And within this recession period, they can take their contract back. If they put down any deposits, they'll get their money back. And both parties go about their lives as if this never happened. One more quick thing before we go to break. I am watching my time. Not necessarily a contract remedy, but a word that's revolved around contracts. We talked about the statute of frauds. Now we have something called the statute of limitations. And guys, this isn't just about real estate. Any lawsuit has a statute of limitations. And what we're saying with the statute of limitations is that you have a specified time to sue somebody. You have a specified period of time to bring action. And if you don't sue within that statute of limitations, then you've lost your right to sue. Again, I'm not an attorney. I'm not a judge. I can't tell you all scenarios and how much statute of limitations you have. What I will say, my non-legal advice, if you plan on suing somebody, do it sooner rather than later, so your statute of limitations doesn't run out. Questions? Okay. Let's take 10. When we come back, we're going to wrap up Unit 9. All right. Are we back? By the way, for those of you interested, I've been asked to, or we're going to stay after class today and work some commission math. So if you're available and you want to hang around, you want to ask some commission math problems, we're going to work some problems together. I will keep recording. So if you're not available, if you need to leave at 2, you'll have access to that. So guys, unfortunately in this class, we got so much to cover. We got such a tight schedule, and going back just isn't an option. So this is why I make myself available to you guys outside of class, because I know you're trying to take a lot in a short amount of information. So I encourage you guys to remember me as a resource. Let me help you. I'll tell you guys, there's not much that hurts me more than when you all show up on test day and say, yeah, I never really understood that. That just hurts me. So please take advantage of what I'm offering you guys. Take advantage of me as a tool, as a resource. And again, we're going to hang out after class at 2 today and do some commission math. Good? Good. Okay. Did I take attendance? I don't think I did. Let's take attendance. Yep. Okay, attendance has been taken. So we talked about specific performance, the non-breaching party making the breaching party perform, or the judge making the breaching party perform. You can rescind your contract, statute of limitations. So when it comes to contract law, basic contract law, what's this mean for us? Let's bring this home. We as agents are not attorneys. I cannot practice law. I cannot draft a legally binding document. I cannot draft legally binding verbiage, provisions. I cannot draft. I'm just an agent. I'm not an attorney. What I am allowed to do is fill in the blanks of our pre-printed forms. So we've looked at 2 of our agency agreements, listing agreement and buyer's agency agreement. We're going to look at our contract. Thank you. We're going to look at our contract. And we'll see, again, you guys, our job is just to fill in the blanks. They provide us with these pre-printed forms to use. And what we're filling in is the negotiable terms, the terms that the parties to the contract agree to. And we need to be very careful. We need to understand that the blanks that we're filling in are asking for something very specific. So in other words, just because we see a blank doesn't mean we can put any old thing in there. The blanks that were filled in are some, for example, purchase price, closing date. Any changes or additions or deleted information needs to be acknowledged by all parties. Now, this dated and initialed is pretty old school, but contract law still says all changes needs to be documented. So if you're going old school and you're negotiating on a piece of paper and we strike out the purchase price and write in a new purchase price, all parties need to agree to that. We'll talk more about our role, our responsibility. Again, page 262 to 263. You know, I hope anytime you guys see something about the broker, for example, broker's authority to prepare documents, that's something we need you to pay attention to, because it's about soon to be you. Kind of the last piece of Unit 9 talks about auction sales. We briefly mentioned auction sales when we talked about our agency disclosure. We said auction sales are a totally different beast. When you guys are answering test questions, whether practice or my exam, state exam, don't even think about auctions unless the question specifically asks you about an auction. So if the question doesn't mention an auction, then y'all just pretend that they don't exist. Fair enough? They're a totally separate thing. In auction sales, there are two types of auctions. An auction with reserve means that the seller has the right to stop bidding, to stop the bidding, if they're not satisfied with how it's going. So with reserve means the seller has the right to say, no, 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 let's stop. We're not going to do this. Without reserve means the seller gets what they get. Oh, good. Without reserve means the seller gets what they get. The bidding will continue. The highest bidder will win. One thing that makes auctions unique, when the gavel comes down and the auctioneer says sold, boom, we are under contract. The auctioneer can bind the seller. That's a verbal agreement. Yes, that gavel comes down, it says sold, poof, we are under contract. Obviously, the next step is to put that agreement in writing. But the auctioneer has the ability to bind the seller. And when they say sold, we're contractually related to each other. Okay, thank you. One more thing I want to mention, because it comes up, and I think it's somewhere in Unit 10, but it's just such a small blip. But I think it's important. Once we get into contract world, we're going to learn a new word called a contingency. It's not in the book. I'm going off book for a second. If it is in your book, like I said, it's a whopping sentence. So I'm making a bigger deal out of it than what your book does. A contingency is dependent on something else. A contingency is contingent. I can't do this if I first don't do that. If I don't do that, then I can't do this. Some examples of contingencies. I cannot buy your house if I don't get a loan. I can't buy your house if I don't first sell mine. So what I'm telling you is, if I don't get loan approval, I'm not obligated to buy your house. That's a contingency. What makes me obligated to buy your house? I get loan approval. If I don't do that, I'm not obligated. If I have a house to sell or a lease before I can buy yours, a contingency would say, if I never sell mine, then I'm not required to buy yours. Some verbiage you guys might see for contingency might say something like, on the condition that. On the condition that. I will buy your house on the condition that I get loan approval. I will buy your house on condition that I sell mine. This is what we need to know about contingencies. There are none built into our sales contract. There are no contingencies built into our sales contract. Do your head one way or another. Can the parties agree to add a contingency? Can they agree to add one? Sure. Anything's negotiable. They can agree to whatever they want to. So what we need to know is there are no contingencies unless the parties agree to add one. We cannot draft contingencies. Again, that's legalese that we cannot do. We'll talk about specifically about loan contingencies. Our contract does say that this contract is not contingent upon the buyer obtaining a loan. So we will see that when we look at our contract. And that gets us through Unit 9. I think the trick to Unit 9 is knowing the key terms. Having a basic understanding of what these words mean. A great place to start with the words is on page 253. There is your key point review on page 264 in your student quiz on page 266. Questions on Unit 9. It's a great flashcard unit. So good question comes in. If we agree to add a contingency and the buyer doesn't get loaned, does that make the contract completely unenforceable? It would terminate the contract. Because what I'm saying is if I don't get loan approval, I can't buy your house. So if I don't get loan approval, I'm no longer contractually obligated to you. I can't do something before this happens. And if this never happens, we don't know each other anything. Good question. Thank you. I wouldn't say unenforceable, but it would terminate. It would end. Yep. Yep. Thank you. Okay. Unit 10. Sales contracts and practices. As I mentioned, our offer to purchase and contract is the highlight, is the star of this unit. We got some other things to talk about as well. So we're going to look at our offer to purchase and contract, our standard form that we use the most often. We're going to talk about some sales contract procedures, how contracts are formed, how we as agents handle offers and contracts when they come in, the in practice piece of it, if you will. And then the last thing we talk about in Unit 10 is alternative land conveyances. Not all properties sold in the conventional method that you and I are familiar with. So we got some other options to convey property. And that's the last thing we do in this unit. So let's talk about our sales contract. The North Carolina Association of Realtors, NCAR, North Carolina Association of Realtors. NCAR is the state level of the National Association of Realtors. Everybody with me? National is the whole country. NCAR is just specific to North Carolina. NCAR has created, they've combined with the North Carolina Bar Association. So NCAR and attorneys have come together to create the forms that we use, the standard forms that we use. And our standard form, one that we use the most often, is our offer to purchase and contract. You don't need to know the 2T. That's just the name of it, offer to purchase and contract. This particular standard form is the one that we most often use, the most often used sales contracts in North Carolina. This is what I need you guys to understand. Sales contract standard form 2T is not the only form that I'm allowed to use. It's not the only contract that I'm allowed to use. I can use any offer to purchase and contract as long as it meets the requirements of the commission rule. I have it there for reference. Again, you don't need to know that number. It's just there for reference. As long as it meets the terms, the standards of commission rule, and it's drafted by an attorney. I think this is a problem topic. I think some reason we get in our heads that if we're not using 2T, we're not writing a contract. It's so important that we understand that we can use any contract as long as it meets the rules. When you hire an attorney, they know what they're doing. For example, you guys, it's not uncommon for builders to have their own sales contracts. So if I'm assisting a buyer in purchasing a new construction, can I assist the buyer to purchase using the builder's contract? Sure, as long as it meets the commission rules and it was drafted by an attorney. Do I have everybody? The reason we're spending time on 2T is because this is the one that we use the most often. This is the most commonly used one, but it's not the only one we're allowed to use. Big picture, brokers don't belong in the sales contract. Who are the parties to the sales contract? Who are the parties to the offer to purchase and contract? There's two parties, and they are buyer and seller. We are not a party to the sales contract. We are assisting our clients or customers and navigating through the contract. So big picture, we don't belong in the sales contract. Specifically, the Real Estate Commission says we can't have any mention of our commission No discussion, and I'll get you in just 1 second. No discussion of commission, compensation, rebates, referral fees, bonuses. Why don't you guys remind me in a chat where we discuss our compensation? Where do we discuss our commission? Julie, if we're not going to talk about it in the sales contract, where are we going to talk about it? We're not going to talk about it in the sales contract. Where do we talk about it? A lot of you are saying agency disclosure. Please remember, you guys are working with real estate agent disclosure is not a contract. It does not create agency. Disclosure is just that. I'm disclosing my agency status to the consumer. I'm noticing a lot of you are also saying listing agreement. You're halfway right. You're halfway right. We also talk about our commission and our buyer's agency agreement. We talk about our commission and our property management agreement. You guys, please remember, agency agreements are employment contracts. May it be a listing agreement, a buyer's agency, or a property management. So where do we talk about our commission? Referral fees, bonuses, whatever. It all belongs in our agency agreements. Yes, ma'am. I had a question. Is that Nicolette?
I was wondering, like, because I think that's why I got one of those Kahoot questions wrong, is because I thought that the compensation wasn't supposed to be listed in that, but I think I already got clarification.
It's not listed in a sales contract, but it is in our agency agreement. Remember, the sales contracts between the buyer and the seller. These are things that buyer and seller are agreeing on. Sellers already agreed to pay me in the listing agreement. Buyers already agreed to pay me in the buyer's agency agreement. Now we're forming the relationship, the contract between the two parties. The other thing specifically that we can't have in our sales contracts is any liability disclaimer. So for example, if your buyer waives the home inspection, they don't want one. They want to save some money and they don't want to get a home inspection. I'm not going to put that in the contract to protect myself. If they choose to waive the home inspection, we're going to document that they chose to waive it. We're going to document that we had the conversation, that we attempted to convince them of the importance of a home inspection. It doesn't belong in the sales contract. I can't put something in there to protect myself. Agreements are the contract. Disclosures are just that. You're disclosing your agency status. You're disclosing to the consumer. Don't you share anything confidential with me until you decide to hire me. How do you hire me? Now we enter into our agency agreements. Remember, you guys, the disclosure is a consumer form. The disclosure is not a client form. By the time you're my client, we're past the disclosure. Disclosure is a consumer form. Yes.
I think I'm just a little bit confused about the contingency that we talked about. Like, so if you are representing a buyer and they want to add a contingency of, the inspection coming back clean and the house being appraised, where would you add that if you're not allowed to do that?
We're going to learn in just a second that the parties to the contract can draft because they're a party to the contract. So maybe your buyer writes their own. If they don't want to write their own, we hire an attorney to draft that for us. The buyer would hire an attorney.
Gotcha.
So
Thank you.
whenever we can't, whenever we need, if one of our forms doesn't fit our needs, and even though the parties can draft their own, that doesn't mean that they should. And we will talk more about that in just a bit. But something like that, we would have to have an attorney. Yep. So we got some rules that kind of regulate how we proceed with contracts. One rule that we have is our Uniform Electronic Transactions Act, also known as UETA. This is the act that addresses electronic signatures, electronic documents. This is the sign of the times. Contracts are required to eventually be in writing. And an acceptable form of writing is an electronic version. We can have e-signatures. Here's the deal. Once the parties agree to allow their e-signatures to count as their signature, they are bound. They can't come back later and say that e-signature is not my actual hand signature. Once the parties agree to use electronic means, their e-signature is binding. You guys, for example, before you join this class or shortly after, if you haven't yet, Lane will hunt you down. Lane asked you guys to sign a registration and a contract with Carolina School of Real Estate. If you haven't done it yet, please do so. So you guys get the email from Lane. You click on the link, and then you are asked to adopt your signature. You guys remember when you went through this? So you're asked to adopt your signature. So you can say how you want your name spelled out. You can pick different fonts. Does your e-signature look like your actual hand signature? Probably not. I also know you guys, you clicked on the terms and conditions and you read those very carefully before you e-sign for Lane, right? Right? What? You guys just signed something without reading the terms and conditions? Don't we do that every day? Every single day. How many of you guys do that? Yeah. I agree to everything you have to say. Let's move on. When you guys saw, if you saw those terms and conditions, one thing it said was you agree that this e-signature you're providing on this contract will count as your legally binding signature. So you can't come back now and tell Lane you want out of your contract with Carolina School of Real Estate because that's not your actual signature. They got to provide that notice. So e-signatures are binding once you agree to let them count. So let's go back a little bit. This is a good refresher. I like that we talk about this twice. Let's talk about the offer and acceptance. And there's this magic moment in time when it goes from being an offer to a contract. So first off, an offer has to be made. An offer has to be received. Who is the offeror? Who is the offeror? If you want to share in a chat, if you want to unmute, either one. Who is the offeror? Hint, it's not the buyer or the seller. Who is the offeror? The offeror is the giver of the offer. Giver, creator, deliverer, I don't care. The offeror is the person giving the offer. So who is the offeree? Again, it's not the buyer or the seller. The offeree is the receivee, the receiver, not receiver. Forget I just said that. The receivee, the person receiving the offer. Is everybody good with this? 9.5 times out of 10, the buyer is the first one making the offer, the seller. But I don't want you guys to get that stuck in your head because the seller can make an offer to sell to the buyer. The seller can counter and have their roles reversed. So when I say offeror, you guys stop saying buyer. When I say offeror, you guys say, that's the person giving the offer, Julie. When I say offeree, you guys say, that's the person receiving the offer. Are we good so far? Our OR and our EE. So the offeror makes an offer to the offeree. The offeree always has three choices. You guys want to rattle them off together? Anytime you receive an offer, you always have three choices. You can accept it, reject it, or counter it. Do you want to do that again? You receive an offer, you always have three choices. Let's do it together. I'll give you plenty of time to write. I'll give you plenty of time to write. You receive an offer and you have three choices. What are your three choices? You can accept it, reject it, or counter it. If the offeree accepts it, they're agreeing to all of the terms exactly how they are. With acceptance, there are zero changes. If the offeree rejects it, the offer is dead on the table. A rejection is a no. Nobody's out anything. Both parties go on, go about their lives as if it never happened. If it's countered, a counter offer is a rejection. And with a counter offer, the roles reverse. A counter offer is a rejection with a but. I'm good with all these terms, but the purchase price and the closing date. So if we have our, let's call it our contract formation wall, our communication. So I have the buyer on one side of the wall. And let's say, as is pretty typical, the buyer is the offeror making the offer to the seller. As an example, the buyer makes an offer to the seller. What are the seller's three choices? They can accept it and agree to all the terms exactly as they are. They can say no, absolutely not, reject it, dead on the table, or they can counter it. They can respond with a, I'm good with all the terms, but this, this, and this. If the seller counters it, the roles reverse. The seller is now making an offer to the buyer. The seller becomes the offeror, making the offer to the buyer. We're going to put agents in this mix in just a second. We will get
I
there.
have a question.
Yes.
So when this happens, and I just want to be clear,
Sure.
like for instance, test question, this would be new, like a new contract, like it's null and void once somebody counter offers.
A counter offer is a rejection. That's right. That's right.
So that means like it would be, if it was a test question and they asked that in the form of, would this be a novation?
Nope. Nope. We're just countering. I'm presenting a new offer to you. So the seller, the roles reverse. The seller's presenting a new offer to the buyer. What are the buyer's three choices? They can accept it, reject it, or counter it. So those roles reverse. The seller's now making an offer to the buyer. The seller says, I'm good with all the terms, but the purchase price. Is the buyer bound to accept the seller's counter? Do they have to accept it? No, they have three choices because now they're the offeree. They can accept it, reject it, or counter. If they counter it, the roles reverse again, right? Anytime we counter, those roles reverse until we finally have the last offeree either accept it or reject it. We keep countering until somebody accepts it or rejects it. So as long as we're still saying, I'm good with all these terms, but consider this. The seller starts up here, the buyer starts down here, right? So an offer's made, a buyer's hoping to get in under. Each counter brings us a little closer, hopefully, brings us a little closer and a little closer together. Until we get to this point, we are so close. If we can make it work, we're going to have acceptance. If we can't make it work, we have a rejection. Yes, ma'am, Felicia.
So these counter offers are oral, or do they have to be rewritten each time someone submits a counter?
Old school way of doing it is striking out the price, putting the new price and having the seller initial and date that, and then sending it back to the buyer, right? That's how we used to do it. Technology is kind of taken over. We can have the parties or the agents involved can kind of negotiate in text or an email. If you were to call me and say, this is my seller's counter, I'm going to say, will you please shoot me a quick text or an email? Because what I want to document, everything. And that includes contract formation. So in practice, we're texting a lot. And then once we come to agreed upon terms, then we go back to our paper and put in those new terms and have everybody signed it. But you guys have got to document the conversations that go back and forth. So you have a text message. Yep.
Thank you.
Yep, of course. All right, you guys, there's this magic moment in time when it goes from being an offer to a contract. Do you think it's important when we're working with buyers and sellers to know that moment that you are under contract? Do you think that's important? Please shake your head. Yes, absolutely. We need to know when, and there's this magic moment in time. When we're going from the offer to a contract, we must have two things. The first thing we must have is the last offeree accepts. The last offeree agrees to all the terms exactly how they are. When the last offeree says, I'm good with it all, we have acceptance. Now, this is important. I'll give you guys plenty of times to write. Please listen for 1 second. This is important. For your exam, when you see that an offer has been accepted, know that it has been signed. For your exam, for your practice questions, you don't sit and have to ask, is it verbal or is it written? I am telling you, it's in writing and it's been signed. In practice, in the real world, when the other agent calls you and says, my guys accept, your knee-jerk reaction is going to be to say, but has it been signed? So acceptance means signature. Absolutely. And in the real world, we need to verify. We need to make sure when they call you, yeah, that's great. I'm glad they accepted. Have they signed it? I'm telling you guys, for your test, when you see the word, when you see that it's been accepted, know that it's been signed. Did everybody hear what I just said? Acceptance means signed. I just took that piece away from you guys. That's one piece. The second thing that needs to happen in order to form a contract, my lines got off a little bit. So we have the buyer on one side, acting as the offeror. We're going to counter and have the offeree. We have the seller on the other side as the offeree, counter to have the offeror. Okay, now we can see that. The second thing that has to happen is that the offeree has to communicate acceptance to the offeror. The person making the offer has got to know that their offer has been accepted. So you receive an offer and you sign it. That's all you do is sign it. Are we under contract? Not yet. We're close. All you've done is step one. All you've done is sign it. What good is it if you don't tell the offeror that you've accepted it? What good is it if they don't know that you have signed it? So signing it is one piece. The second piece is communicating acceptance. What I'm telling you is communication has to cross the line. So when we talk about contract formation, and I'm going to encourage you guys in just a bit, I might as well tell you now, I'm going to encourage you guys in just a bit on your exam. You're going to have a scenario. I swear the test question's like this long. And it's going to walk you through an offer is made and it's countered and it counters back and forth a couple times. And the end of the question wants to know who's the last offeree that has to accept it and who's the last offeror that has to get communication of acceptance. And my suggestion to you is to draw the line and walk it back and forth. So you have a buyer's making an offer to the seller, offeror makes an offer to the seller, the offeree. What are their three choices? They can accept it, reject it, or counter it. If they counter it, the roles reverse. And in this example, the seller is now making an offer to the buyer. Do I have everybody? The seller countered it. They rejected with a but. Now the buyer has to consider the things after the but, right? I'm good with all the terms, but purchase price and closing date. What are the buyer's three choices? Accept it, reject it, or counter it. If the buyer accepts it, that means they're agreeing to all the terms exactly how they are. So if the buyer accepts it, at this point, are we under contract? Are we? Not yet. We're close. I still have to have another step. And that other step says that communication of acceptance has to cross the line. The person making the offer must know that you signed that offer. Take care.
Okay, I think I have a question here.
Okay, please.
So okay, we're talking about the last offeree accepting. Okay, that
Mhm.
means they don't want to change nothing. They're good to go.
Right.
At that point, they can be held to that signature, right? I mean, is that?
You mean held
but-
to that signature?
So you said that in an acceptance, that it always means that it's been signed, right?
For your
By
test,
the,
for your test, yes.
okay, in the real world, like I'm just trying to.
Don't worry about
put
the
it
real
together.
world just yet. We're in pre-licensing world.
So if it's been signed by them, it doesn't mean that it's an actual go. It just
That's
means that they're
correct.
signing it. They're saying.
They've done one of the two steps. They've done one of the two steps. Guys, what if, here we go. What if the buyer signs and then the buyer dies? Did communication of acceptance ever happen? Do we form a contract? No. What if the buyer signs and then changes their mind before we notify the seller? Do we have a contract? No, it's two steps. Let's think of this as a two-step process. Step one says the last offeree signs, the last offeree accepts. The second step says we communicate with the person that gave us the offer. Don't they have a right to know that you've accepted? How do they know otherwise if you don't tell them? It's two steps. We're getting ready to take a break. When we come back, we're going to throw agents into this mix because more often than not, agents are involved in this mix. So I'm not done with this conversation yet. I did just have a request to go back. So the offeror is the giver, the offeree is the receivee. Anytime you receive an offer, you have three choices. You can accept it, reject it, or counter it.
So Julie?
Yeah.
So say the communication crosses the line to the agent, but not the specific offeror. Does that still count as the communication crossing the line?
I'm going to bring agents into the mix right after break. So I will answer that as soon as we
Okay.
get back. Yep. We'll bring agents in. What happens when an agent gets involved? How do we communicate? We will do that as soon as we get back from break.
Okay.
Okay. Everybody have these two steps. Must. You guys see my absolute word there? Must. The last offeree accepts. The offeror needs to know that the offeree has accepted your offer. So let's take a break. And when we come back, we'll bring agents into the mix. Are we back? Okay. I am taking attendance. Before we bring agents into the mix, let's make sure we're good on the words that we are saying. So remind me, everybody, I want to hear from everybody. For attendance purposes, forget I just took attendance. For attendance purposes for this hour, everybody in the chat, tell me who is the offer or. Everybody. If you don't know, tell me you don't know. I'm not looking for right or wrong. I'm looking to make sure that you're here and paying attention. For attendance purposes, I want everybody to tell me who the offer or is. The offer or. Not looking for right and wrong. I'm looking to make sure you're here. You don't tell me anything in the chat right now, you don't get credit for this hour. Say something. The offer or is the giver of the offer, the giver of the offer, the person making the offer. So then the offeree is who? The offeree is the offeree is the person receiving the offer. So you have two parties when we're forming an offer. One party is giving an offer to the other. Those parties have names. The party giving the offer is the offeror. The party that they are giving the offer to is the receivee or the offeree. Every time you receive an offer, you always have three choices. What are they? You can accept it, reject it, or counter it. I'm going to have you guys dreaming about this stuff tonight, which is good. That's what we want. This magic moment in time, when it goes from being an offer to a contract, there are two steps. There are two things that have to happen. The last offeree accepts. For your test, it means that they sign. And then they've got to communicate the fact that they accepted your offer to the person that gave you the offer. What good is it if the offeror doesn't know that you've accepted it? What good is it? Not good at all, is it? You got nothing right yet. The person making the offer. So we have communication of acceptance. We have the last offeree accepts and the communication of acceptance. Do I have any questions before we bring agents into the mix? Okay. When we get involved, when it comes to communicating acceptance of an offer, when it comes to offer negotiations, communicating acceptance of an offer, terminating an offer, once you communicate to the agent, it is just as good as communicating to that party. Once you tell me, you might as well be talking directly to my client. You might as well be talking directly to the side of the wall, the side of the line that I'm on. So let's look at our line again, our communication of acceptance. We still have the buyer, but now we have the selling agent standing on the side with the buyer. who is going to be the offeror. SA is selling agent. Then on the other side, you have the listing agent standing with the seller, who is the offeree. When it comes to communicating acceptance, when it comes to negotiating, communicating acceptance, or terminating an offer, telling me is just as good as telling my client. So let's walk through this again. Actually, let's start over. You are a buyer's agent. You're a selling agent. And you show your buyer a property this afternoon. And they walk in the front door and they go, holy crow, this is what I've been looking for my whole life. This is my dream home. Let's make an offer. You go back to your laptop, desktop, whatever. You pull the information that you need, gather the information you need to complete the offer, fill in the blanks on behalf of your buyer. All the terms that they want to offer, how much do you want to offer, purchase price, deposits, closing date, all that. You complete the offer, you fill in the blanks on behalf of your buyer. You send it to your buyer to sign. So they have signed their offer. Then you deliver that offer to the listing agent. So we've completed it. We've had our buyer signed it, and then we deliver it to the listing agent. Present the offer on your buyer's behalf. The listing agent calls the seller, their seller, and says, we have an offer. The seller has three choices. They can accept it, reject it, or counter it. Am I going to assist them in deciding which one to do? Absolutely. Absolutely. What if we have multiple offers? Now we got several things to consider. That's why the seller hired me, is to make sure I'm getting them the best offer. There's more to consider than purchase price, as we will see in just a bit. So for simplicity, let's say the listing agent, let's say the seller, upon reviewing the offer with their agent, they're good with all the terms and they accept it. By accepting the buyer's offer for our purposes means that they've done what? They have signed it. Are we under contract? The seller signed it. Are we under contract? No. Does anybody know that the seller signed it? No. So the seller signs it. That's one step. The seller calls their agent and says, I have signed this offer. Has communication of acceptance crossed the line? When the seller calls their agent, did we cross that communication line? No. So are we under contract yet? No, we're still on this side of the line. So the seller calls their agent and says, yes, I accept. Then the listing agent calls the selling agent and says, my guys have accepted your offer. Did communication just cross the line? Boom. Congratulations, you're under contract. The buyer's agent hasn't even called the buyer yet, have they? So what's the next step? What's the very next thing they want to do? Yeah, tell your buyer the good news. And guys, when you're calling your buyer at this point, this isn't a, are you sure you still want this? This is a call that says, congratulations, our offer has been accepted and we are under contract. Once communication crosses the line, may that be directly between buyer or seller, or may you throw agents into the mix? Communication has to cross the line. And when you have agents involved, communicating to me is just as good as communicating to my client. As we just said, the very next step that this agent wants to do is call their buyer and share the good news. Guess what? That dream house you wanted, I got it for you. You're under contract. I've got to have these two things. I really suggest you guys draw the line so you can see. What you need to see is when that communication crosses the line, because that is that magic moment in time. It's a two-step process, and we have to have both steps. The last offeree accepts, communication of acceptance crosses the line. We will talk about how we communicate next. Bear with me. I promise you I'm getting it. What questions do I have now that we threw the agents into the mix? This deals with negotiating an offer, accepting an offer, terminating an offer, terminating a contract. Yes,
I have a question.
please.
Sorry. Hey. So communication to the party, but also like the signature, right? Like it has to be both of those.
That's
no?
what we did when we accepted it. So when the seller accepted, they signed agreeing to those terms. Step one. And then step two, again, you guys, let's pretend that you're the buyer and you make this offer to the seller. Don't you have a right to know if they accept it or not? Don't you think you deserve to know that? Sure. If they don't tell you they've accepted it, how do you know? So they've got to communicate acceptance. And how we communicate acceptance is to have that offer cross the line. For both of your exams, mine and your state exam, you can have scratch paper. Once again, I encourage you guys to draw this out. You got some practice problems on your book and in Learn Test Pass. Some of these problems get really long and really detailed. I need you to take this information and a counter and it going back and forth and da-da-da-da-da, and I need you to draw it out. And what you're looking for is that moment in time when the last offeree signs it and when communication of acceptance crosses the line. Yes, ma'am.
I had a question just involving the communication to either party's agent is deemed communication to that party. So I kind of got confused when the listing agent contacts the selling agent, because in my head that makes me think like that's the communication to the party's agent. Does that make sense? Like, so
it is. That's what put us under contract. When the listing agent called the selling agent and said, my guys have accepted.
Okay,
boom, we're under contract.
Okay, so we're under contract when that
That's
listing agent called the selling agent before the selling agent contacted their buyer.
Because when it comes to negotiating an offer, creating an offer, terminating an offer, whatever you tell me, you might as well be talking directly to my principal.
Okay, perfect. Thank you.
Thank you. So how can we communicate acceptance? Well, bottom line, you guys, we can communicate acceptance in any way that the parties agree. There is no right or wrong answer as long as the parties agree. So you have some traditional methods. You can pick up the phone and say, my guys have accepted. That's a communication. You can send a fax. You can send a snail mail. I got snail mail rules in just a second that we'll look at. You could also communicate via electronic methods, emails, text, e-signatures. There is no wrong method of communication as long as the parties agree. How are we going to communicate? Another thing that your test likes to do, it'll tell you, for example, back in our previous example, the seller accepts. The listing agent calls the selling agent and says, we've accepted. The listing agent calls the selling agent. And then the listing agent follows it up with a text message. And then they send an email. What puts us under contract is the first time that communication crossed the line. Everything else is just following up. So in this scenario, which one put us under contract? When the listing agent called and said, my guys have accepted. Now, obviously, we need to get a signed copy to the selling agent, right? We need to make sure that they have a copy of the contract in their hand. That's an afterthought, because which method put us under contract? When they called and said, my guys have accepted. If I email you the offer, I may follow up with a text. Just sent you the offer. Did you get it? Just now we're a contract. Just sent you the contract. Did you get it? What put us under contract? When I emailed it. Is everybody with me? And the other length of these test questions you like to get is there's several different forms of communication. So when you guys are dissecting these test questions, I need you to look for when the last offeree signs, when communication of acceptance crosses the line, and all we needed to do is cross the line the first time. Anything after that is called a distractor. Your book, page 286, talks about something called the Mailbox Rule. This is one of the oldest rules that we have. This dates back to the days of the Old West with the Pony Express. We're not communicating as much via snail mail anymore, but guess what? As long as snail mail is still around, we still have the Mailbox Rule. And what the Mailbox Rule says is that once the signed contract is placed in the mail, communication of acceptance has happened. Once you take that signed contract and put it in the federally related mailbox, this is not the mailbox on your front porch. This is the big blue box. We still see those things around, or taking it to the post office. Once you put it in the mail, communication of acceptance has happened. You can follow up with a phone call, whatever. It doesn't matter that the recipient won't get it for 3 to 5 to 8 days. It's considered accepted once you put it in the mail. And the other important thing to understand about the Mailbox Rule, the Mailbox Rule only applies when we're creating a contract. The Mailbox Rule doesn't apply when we're negotiating or when we're terminating. It only applies for contract formation. Are we doing it this way anymore? Not much, but as I said, as long as the mailbox is still around, the Mailbox Rule is, and we need to understand when it applies. Once you place the contract in the federally related mailbox, communication of acceptance. So now the question says that you run to the post office and you stick it in the mail, and then you contact the other party via phone to let them know you stuck it in the mail. Which one put us under contract? The first time communication crossed the line. The Mailbox Rule says once you placed it in the federally related box. The phone call is just a follow-up to let you know it's coming. We look at our contract just a bit, we're going to see that we have a place for the parties to indicate how they'd like to be communicated with. A contract handles that for us, so we don't have to sit and wonder. A contract handles that for us. I do think it's important that any form of communication is allowed. There's no wrong way to communicate as long as the parties agree. So let's look at an example together. An owner offers to sell a prospective buyer. The offer states that the acceptance must be made by email message only. What is the only acceptable form of communication? Don't read the rest of it. What is the only acceptable form of communication? Email. What's it say? The offer states that the acceptance must be made by email message only. Instead, the prospective buyer leaves a phone message informing the seller that he's accepted and signed the offer. But guess what? The offer's not been legally accepted, because what does the offer say that the only acceptable form of communication is? The offer says it's email. So if the parties limit, if the parties dictate, again, communication can happen in any way as long as the parties agree to it. In this case, they said email or bust. So when you call, what do you have? Nothing. Again, we'll see in just a second. We have a whole page of how we can communicate, acceptable forms of communication. So let's talk about how an offer is terminated. Everybody please note that says offer. Everybody see that? Termination of an offer. I'm not under contract. We still have the offer. So how can we terminate an offer? Well, we said a rejection will kill the offer. A counter offer is a rejection with a but. Other things that can terminate an offer. If the offeree, if the receivee fails to accept within a prescribed time period. The offeror has the option of putting an expiration date on their offer. The offeror can say, this offer is good until Wednesday at 5 p.m. And if we don't have acceptance by Wednesday by 5 p.m., the offer has been terminated. Can also terminate within a reasonable amount of time. Who gets to determine what that reasonable amount of time is? Usually it's the offeree. I'm sorry. Usually it's the offeror, the giver of the offer. If they decide you've had their offer for too long, they can pull it out. This is important. Please listen and please be prepared to write down what I'm getting ready to say. An offeror can reject their offer at any time prior to acceptance. I will say that again. The offeror is free to reject their offer at any time prior to acceptance. So if they feel that the offeree has had their offer for a reasonable amount of time, they can terminate their offer. If they make an offer right now and they decide at lunchtime that they don't like it, they don't want to do it, they can reject their offer. The offeror is free to reject their offer, free to take their offer back at any time prior to acceptance. The other thing that will terminate an offer is death of either party. If buyer or seller pass away while you're negotiating the offer has been terminated. Please note, once a contract has been formed, death is not an out. Once we are under contract, buyer and seller are expected to carry through with the terms of their offer, their contract. And if either party pass away once we're under contract, their heirs are expected to carry on with their contract terms. And if the heirs can't or won't, they suffer the consequences of breach that are spelled out in the contract. The reason being, once we sign a contract, if either party passes away, the intent was for them to fulfill this contract. Once we are under contract, death is not an out. Ain't that something? Death is only an out when we're negotiating an offer. Questions? So starting on page 287, we're going to go through our contract. We're going to look at some terms of our contract. 287 to 292, top of page 293. It just goes through some various provisions of our contract. Obviously, we're going to talk about these, but I want to point them out that there's a separate, there's a place in your book, those pages in your book that talk about it as well. Before we get into your contract, though, I just want to have a conversation to kind of lead us up to it. Give us some information and some knowledge so we know what we're looking at when we look at our contract. We talked about the forms committee through the North Carolina Association of Realtors, the joint effort with the North Carolina Bar Association. They came together to create these standard forms that we're allowed to use. Our agency agreements is another form that they created for us. Any of your forms, and if they don't provide you with one, then we need to get an attorney to draft one up. But something else that they do besides the contract, they provide a separate document called Guidelines for Completing. Our agency agreements have a guidelines, our offer to purchase and contract has a guidelines. When I am in sales, I tend to operate by a pretty simple philosophy. When in doubt, find out. Don't guess, don't assume, don't throw something in just for the sake of throwing something in. If you don't know how to complete the form, most of our major forms have a guidelines that help give us information, insight on what they're looking for. If the guidelines don't help you, you got a broker in charge. You got seasoned agents in your office. Once you become a member of the North Carolina Association of Realtors, you have access to a legal hotline. What a part of your member benefits? You can contact a dang attorney and ask them questions. You can email them or call them. That's part of what we pay for. I've reached out to them before. I was shocked. Dude got back to me in like 20 minutes. I was blown. I thought, well, this is going to be a good 3 or 4 days as attorney after all. Yeah, got right back to me. So legal hotline. Guys, my point is, once you get licensed and you get involved, the tools and the resources to help assist you through these transactions are there. And you need to be willing to use your resources and get the information that you need. So the guidelines for completing also gives us some guidelines, things that we should take into consideration when we are completing standard form 2T on behalf of a buyer or seller. The guidelines suggest type, if at all possible. This was a bigger thing before the electronic world that we're in today. I remember electronic signatures coming into real estate. I have been at it that long. I remember electronic signatures, which means when I first started in this industry, we were still doing everything with pen and paper. I remember my agents telling me stories about writing up an offer on the trunk of their car in the Bojangles parking lot. It used to be like that. Today we have electronic communications. It's a lot easier to type. However, if it's still not possible or feasible, if you cannot type, you need to fill it out in pen and you need to fill it out legibly. Do not use pencil or purple crayon to create a legally binding document. We're going to do it in pen. Some of your handmanship, my goodness, some of your penmanship, we need to work on that. You guys are going to type, right? If I don't know what it says, the judge isn't going to favor you. The guidelines also tell us to fill in all blanks. If you have, let me say this, when we're completing standard form 2T specifically, we're never going to leave a blank blank. If you have a scenario where the blank doesn't apply to this situation, you write N/A for not applicable. By filling everything in, that solves two matters. First off, if you leave a blank blank, doesn't that make it really easy for the other side to slip something in? Yeah. So let's reduce temptation. Don't leave a blank blank. The other thing, by putting NA or 0, for example, will tell the other side that you've acknowledged that nothing goes into that blank. They're not standing there going, gee, I wonder if she meant to put something in there. You've acknowledged the blank. So we're never going to leave a blank blank. We need to be precise. As we mentioned earlier, our jargon does not belong. We speak broker, buyers and sellers do not. So we need to make sure that all of our acronyms and all of our fancy jargon, we need to be precise. If you're making any change, addition, or deletion on paper, it needs to be initialed and dated by both parties. And then part of our job as the agent is to review the various contract provisions with the parties. Y'all, I'm here to tell you right now, the majority of the time, your buyers and sellers are not reading that contract. Some do. You have some readers out there. I appreciate readers. But for the most part, buyers and sellers are not reading that contract. Why? Because they hired you. They trust that you have the knowledge of the contract to get them through this transaction. They trust you, you guys. Even though they're not going to read it, we still have to review the various provisions. We have to have conversations about the important pieces, make sure that they understand various things. Y'all, it blows my mind. I'll write up an offer for a buyer and I'll send it to them through .loop, and I'll send them a message that says, here's your offer, Look over everything before you sign it and let me know if you have any questions before you sign it. A minute and a half later, I have a fully signed offer in my inbox. Did they read that whole thing in a minute and a half? I want to sign up for that class if they did, right? How do we read like that? You guys with me? They are not doing it. They hired you to assist them through this transaction. And part of our job is to have an understanding of their offer to purchase and contract. Have conversations, buyer consultations, listing appointments. So very important that they understand. By the way, NIB, I'm off book, not in book. I'm sorry, I should have mentioned that earlier. I hope you weren't looking. We're going off book for just a second, just a conversation. Again, trying to give you some things before we actually look at the contract. In standard form 2T, we're going to introduce you guys to something called a due diligence fee, a due diligence period, and an earnest money deposit. We're going to talk about what all these means. I like to have this conversation before we look at our contract, as opposed to trying to explain these things to you while we're looking at the contract, so we can expose ourselves to it first. So we're going to talk about what this due diligence fee is, the due diligence period, and the earnest money deposit. And then we will see verbiage for all when we look at our contract. So first off, let's break this down a little bit. We're talking about a deposit and we're talking about a fee. Generally speaking, a deposit is refundable and a fee is not. Now I have exceptions in my contract. Maybe you can get your deposit, or maybe you don't get your deposit back. Maybe you do get your fee. That's why I'm speaking in general. A deposit is money that you put down that you may be able to get back. A fee is money that you put down that you may not get back. A fee is non-refundable, generally speaking. So generally speaking, what we just learned, if we talk about the due diligence fee, is that refundable? Generally speaking, is that refundable? Nope, it is not. The due diligence fee is a negotiated amount between the buyer and the seller. It's an amount of money that the buyer pays the seller. Did y'all just hear me right? The buyer pays the seller. We agree, we negotiate when we're forming the contract how much the buyer is going to pay the seller. When we say it's completely negotiable, there's no formula. There's no science behind how much this amount is. When it comes to our fees and deposits, the real estate commission is Very helpful. Y'all want to know what the real estate commission tells us to help guide us through how much? Y'all want to know what they say? The due diligence fee, the amount of the due diligence fee is whatever the buyer is willing to offer and the seller is willing to accept. Isn't that helpful? Guys, there's no formula. There's no, if the purchase price is this much, then due diligence fee should be, it's a completely negotiable amount. If the buyer offers 0 and the seller accepts 0, we have formed a contract with how much in due diligence fee? 0. It's negotiable. The buyer offered, the seller accepted. So I see question marks all over your face and you're going, Julie, why in the world would the buyer pay a seller? We go under contract and you look at your buyer and you say, I need to get me a check for this amount made out to the seller. Why in the heck would the buyer pay this fee? Why would they pay this to the seller? Our contract tells us what they're paying for is their right to terminate. The contract goes a little bit further and says, we're paying for the buyer's right to terminate during their due diligence period for any reason or no reason at all. Who remembers caveat emptor? Good time of year to talk about caveat emptor. Buyer beware. Does the seller have to disclose? Nope. Does the seller have to repair? Nope. The onus is on the buyer to learn as much about the property as they possibly can. They're doing their inspections and their investigations during their due diligence period. During that time, they have paid the seller for the right to terminate for any reason or no reason at all. So let's say your buyer starts doing a lot of inspections and negotiations and they got this whole laundry list of problems with the house. There's structural issues, there's electrical issues, the roof is 30 years old, the basement floods in the springtime. The inspector helps the buyer determine all these things. As I rattled off that list, did you guys just hear a bunch of dollar signs? Usually when you talk about structural issues, that's not cheap. Electrical is not cheap. A brand new roof is not cheap. If the buyer finds all these issues with the home, they may choose to terminate the contract during their due diligence period. They are paying for that right to terminate. What if, we'll get more back to that in just a second. Any reason or no reason at all. Your buyer literally could wake up tomorrow and say, nah, I don't want this house. And they could exercise their right to terminate. During the due diligence period, the buyer's not considered in breach. Question comes in, is due diligence not needed on new properties? Is part of the contract to be negotiated. Guys, there's no such thing as a perfect house. And that does include new construction. So should your buyer be encouraged to have an inspection done when they're buying new construction? Absolutely. Is everybody good with me here? No such thing as a perfect home. I'm sorry. I hate to break that to you. Humans build it. Humans make mistakes. It doesn't exist. All homes have some kind of issues, some kind of problems. What we're trying to determine during the due diligence period is your buyer's tolerance level. We're helping them discover these problems so they can decide in their sole discretion if they want to move forward with or terminate the contract. So during due diligence, do your head one way or another. If the buyer terminates during due diligence, do you think they'll get their due diligence fee back? You can say yes or no with your head. If they exercise their right to terminate, do you think they're going to get their due diligence fee back? And the answer is no. The seller will keep that because that's what the buyer paid for. If the buyer chooses to terminate, they have exercised their right to terminate. They have this window during the due diligence period to learn as much about the property as they possibly can. And now that they know everything with their agent's assistance, once they've learned about the property, they decide in their sole discretion if they want to move forward with or terminate the transaction. If they terminate within the due diligence period, the seller will keep their due diligence fee. I'll talk about earnest money in just a second. We're just focusing on due diligence.
Julie,
Probably, yes, ma'am.
is this for every contract, like for every person that we would deal with, as far as, you know, a buyer, for a buyer's agent, would we want to recommend, or is this something that has to be implemented?
If you're using standard form 2T, due diligence P, due diligence fee, and due diligence period are a part of it. If you
Okay.
don't want to deal with it, have an attorney draft you another contract. Do you have to have a contract with due diligence? No.
No.
Do the parties have to have it? No. But if you're using standard form 2T, this is part of it.
Okay, thank you.
Yep. So the buyer terminates within their due diligence period. That's their free look time. And if they choose to terminate during due diligence, the seller will keep the due diligence fee. Guys, we said a fee is generally non-refundable. Remember when we just said that? A fee is generally non-refundable. The only time that the seller may have to give back their due diligence fee is if the seller breaches. If the seller doesn't do what they've promised to do, if the seller breaks their promise, that's the only time that a buyer may be entitled to their due diligence fee back. And if the parties aren't in agreement, we got to get a judge involved. Remember, if parties can't agree to agree, the judge will decide for them. If you guys have been following this crazy market we're in, due diligence fee has been wild. Buyers are using due diligence to help themselves make their offer look better in a multiple offer situation. I've seen 6-digit due diligence fees. Who in the heck has that kind of money? That's what I want to know. I want to meet that buyer that can give the seller $100,000 for the right to terminate. I think as this market adjusts, we're going to start seeing more reasonable. But again, you guys, it's so important. There is no formula. There is no right answer. It's whatever the buyer's willing to offer and the seller's willing to accept. Great question comes in. How long is the due diligence period? It's a completely negotiable time period. How long the buyer gets in due diligence is negotiable between the buyer and the seller. That's a blank that we have to fill in. Is it 2 weeks? Is it 4 weeks? Is it 10 weeks? Buyer and the seller have to agree to that. When we get into Unit 21, we're going to talk about the buyer's contract to closing process and the things that they should be encouraged to do during that time, especially during their due diligence period, inspections, appraisal, all that good stuff. So we're going to talk about wanting to have our due diligence period long enough to get the inspections done, get the appraisal done. And that can vary from market to market. Because guess what? If I'm swamped with contracts, so is our home inspector, so is our appraiser, so is our surveyor. You guys with me? So when we're busy, they're busy too, and we may need a little bit more time. Each market could dictate how long the due diligence period is. Completely negotiable. So the due diligence fee is one piece of it. Buyer pays the seller. They actually write a check to Mr. and Mrs. Seller. Sellers are encouraged to get that thing in the bank. Make sure it doesn't bounce. There's a provision in our contract that says what happens if it bounces. Sometimes they do. So our contract covers that. We'll see that. I've had sellers say, oh, I'll wait till closing before I deposit this. No, 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 no. Get it in the bank right now. It's your money. And unless you breach, you get to keep it forever and ever and ever. The second negotiable money, other than the purchase price, the second negotiable money in the contract is something called the earnest money deposit. The earnest money deposit goes to an escrow agent. An escrow agent is somebody that's going to hold this money. It's an impartial third party that's going to hold this money on behalf of the buyer and the seller. Typically, an escrow agent is our closing attorney. Some real estate firms will also act as the escrow agent. More often than not these days, we're seeing the closing attorney act as the escrow agent. The earnest money deposit is once again a negotiable amount. Is it $1? Is it $100,000? It's whatever the buyer's willing to offer and the seller's willing to accept. What the earnest money deposit does, it shows the buyer's good faith. The seller wants to know that this is a serious buyer. The seller wants to know that they're legitimately interested in buying their home. They're not just out there kicking tires and wasting their time. So how can the buyer prove this to the seller? They put down an earnest money deposit. So your buyer goes under contract. If you're the buyer's agent and you get your communication of acceptance at 11:49 a.m. on October 11th, yeah, you're under contract. Do the little mini celebration. I'm all about celebrating the small wins in transactions. So woo, we're under contract. So you call your buyer, text your buyer, whatever, and you say, congratulations, we're under contract. How do you feel? Are you excited? I'm so happy for you. And then you say, I need you to meet me somewhere because I need to get 2 checks from you. One made out to the seller and another one made out to the escrow agent. Once the contract has formed, the buyer owes the due diligence fee and the earnest money deposit. So now the question is, Julie, will my buyer get their earnest money deposit back? And the answer to that is, it depends. Let's all understand, the buyer's not considered in breach until after the due diligence period. We just said our due diligence period was the buyer's right to terminate for any reason or no reason. The due diligence period is a time is of the essence. Our due diligence period is up on whatever date we decide at 5 p.m. The contract says 5 p.m. We just have to agree on the date. So as long as we're still in due diligence, the buyer's not in breach. If they terminate at 5:01 on our due diligence date, now they're in breach. That's what we mean by a drop dead date and time. They have until 5 p.m. on this date to exercise their right to terminate. And if they terminate for any reason after due diligence, now they are in breach. So, do they get their earnest money deposit back? If they terminate within their due diligence period, they will get their earnest money back. So if the buyer exercises their right to terminate within due diligence, the seller keeps the due diligence fee, the buyer gets their earnest money back. If the buyer's in breach and they terminate after due diligence for any reason, now the earnest money goes to the seller. So whether or not they get their earnest money back, just depends. The contract tells us, in the event of buyer breach, the buyer will get their, or I'm sorry, the seller will keep the due diligence fee. They will get the earnest money together. And those two monies together equal the seller's liquidated damages. Remember what we just said liquidated damages were money damages that we agree to when we're entering into the contract. That's part of our negotiations. How much due diligence is the buyer willing to offer and the seller's willing to accept? How much earnest money is the buyer willing to offer and the seller's willing to accept? And the two amounts together equal the seller's liquidated damages. And the contract says that the seller's liquidated damages are their sole and exclusive remedy, which means this is all the seller gets if the buyer terminates. They can't sue the buyer. I mean, they can try, but the judge is going to look at it and say, "What? Why are we here?" The contract says sole and exclusive remedy. Question comes in, buyer never gets their due diligence fee back unless the seller breaches. That's absolutely correct. The only time that the buyer may get their due diligence fee back is if the seller's in breach. And if the seller's not willing to sit down and write a check, now we got to take them to court for compensatory damages. Don't I have an invoice and a receipt showing how much I paid you in due diligence? Yep. So in the event of the buyer breach, this is all the seller gets. Listing agents, as this market starts adjusting and we're seeing these numbers come down, I'm telling you, the last buyer's market we were in, we were seeing like due diligence for $50, right? Listing agents, you need to make sure that your sellers are comfortable with those numbers. Because if your buyer breaches 1 hour before closing, all the seller gets is the due diligence and the earnest money deposit. There are no other damages. And let's think about this. If your buyer terminates 1 hour before closing, the seller presumably has had to find somewhere else to live, right? Maybe they've under contract to buy another home. Maybe they signed a lease. So we want to make sure that what they collect in the event of the buyer's breach is enough for them to terminate their contract, terminate their lease, or wherever else they're deciding to live. Yes, ma'am, Ashley.
So if you, just so I'm making sure I'm understanding, you would
Please.
either write a due diligence, you would either do a due diligence fee or a due diligence deposit, depending on how your buyer wants to present it. And then you would also do earnest money, depending
So there's
on.
a due diligence fee and an earnest money deposit. There is no due diligence deposit.
There
So
is
it's
no
a due diligence fee, and then it's an earnest money deposit, and both are completely negotiable. Yep.
Got it. Thank
Yep.
you.
Thank you. So buyer breach, this is what the seller gets. What happens if the seller breaches? Well, the buyer can sue the pants off of them. The buyer can go after the seller for compensatory damages. The buyer can go after the seller for specific performance. Remedies are harsher for seller breach than buyer breach. The reason being, the seller is the one that initiated this whole thing to begin with by putting a for sale sign in their front yard. They're the ones that started this. If they didn't have their home for sale, that buyer and seller would probably never get together. You guys with me? So because the seller originated this, because they started this whole thing to begin with, the remedies for seller breach are much harsher. Remember, we just said the seller only gets due diligence and the earnest money. That's it. The buyer, the buyer can go nuts. They could sue the pants off the seller if they wanted to in the event of the seller breach. Okay, so the two, other than the purchase price, obviously the purchase price is a big negotiable point. But now we got some other monies involved as well. We got a due diligence fee. We got an earnest money deposit. Let's go ahead and take our break. We come back. We've a lot of doom and gloom about what it terminates and who can sue who. When we come back for break, we're going to talk about what happens if this thing actually makes it to closing. Sometimes they go to closing. So we'll talk about what happens then. So let's take 10. All right. Are we back? So I am taking attendance. Ooh, Fred, I just got you. Right on the brink there. Okay. So we talked about what if this thing doesn't close? Well, what happens if it does? They don't all terminate. Sometimes they do close. So what if we actually make it to closing? The due diligence fee and the earnest money deposit will be credited back to the buyer. If we make it to closing, let's think of these as down payments. Once they make an earnest money and a due diligence payment, that's that much less that they have to bring to closing. They've prepaid that amount. So it'll be credited back to them at closing. The due diligence fee then is going to be debited from the seller at closing. They already received it once. Remember, we took them a check when we went under contract. Do I have any accounting minds in the call? If not, I'll fix it real quick. What's accounting 101 say? How do you erase a credit? You erase it with a debit. So we credit it to them at closing, or sorry, at contract formation when we gave it to them. And now fast forward when we go to closing to balance it out, to make that zero, we're going to debit the seller. Unit 21 is our closing unit. I like 21 a whole lot because we finally get to go to closing. And part of what we get to do in unit 21 is help our buyers figure out how much they're going to get. Help our buyers figure out how much they have to bring to closing. And we're going to help our sellers figure out how much they're going to get. So we got to look at all the buyers' debits and credits so we can help them determine their bottom lines, their bottom numbers. And thank you for telling me that you're back from break. Please make sure you do so. So that's kind of the intro of where we're heading. Again, I do think it helps to have a conversation about these fees and deposits before we actually look at our contract. So, do I have any questions so far? Understanding this is the first time we've seen this. So what we're going to do now, let's see, the only difference, is the only difference that the earnest money is refundable. Maybe it's refundable. Remember, the buyer's only going to get it back if they terminate within due diligence. If they terminate outside of due diligence, it's not refundable. Again, to simplify it, the due diligence fee, the buyer's paying the seller directly for their right to terminate. For what reason? For any reason or no reason at all. Seriously, you guys, honestly, they can wake up the next day and say, I don't want to buy, and they can exercise their right to terminate. That's what they paid the seller for. The earnest money goes to an escrow agent, a third party, an impartial third party holds it. So let's go off PowerPoint for a bit. We're going to go into Learn, Test, Pass. And if we look at the Unit 10 material in Learn, Test, Pass, in Unit 10, I have our standard Form 2T, offer to purchase and contract with highlights. As we discussed, same thing with our agency agreements. If it's highlighted here, it's discussed in the syllabus. And the Real Estate Commission says, if you want to know what you're going to see on your state exam, we study the syllabus. So at a minimum, I need you guys to look at the highlights because that could be a good candidate for a test question for your state exam. So the form we're looking at is the offer to purchase and contract. Let's understand that this form serves two purposes. It serves as an offer to purchase and upon acceptance becomes a contract. Everybody see that? It's a twofold term. We can use this to present, negotiate our offer, and then upon acceptance, it becomes a contract. The first provision is terms and definitions. We're going to spend like the first 2.5 pages defining things. If you guys don't do anything else, look at the first 2.5 pages. Look at these terms and definitions, because this is what we're explaining to the consumer. Remember, they're not reading this. So we're using this information to help us put words in our mouth so we can have conversations with our buyers and sellers. So the first thing we need to define is, who are the parties to the contract? Who is the seller and who is the buyer? I need full legal names of each individual person. All sellers that have to sign the deed to convey it and their spouses need to be listed here. And everybody has their own name. Y'all don't call me Mr. and Mrs. Ryan Campbell. That's not my name. We are two separate people, Ryan L. Campbell and Julie A. Campbell. So you want to identify us both. Same thing with the buyers, full legal names, individual people, everybody that plans on receiving the deed, everybody that plans on being a part of that deed needs to sign as the buyer. Then we identify the property. What's the property we're referring to? So we have a street address, city, zip, county. This is a North Carolina form, so we don't have to fill that in. We know that the property is located in the state of North Carolina. If it's not, I can't use this form. And then we have a legal description. Remember when we said back in Unit 4, the whole way back in Unit 4, that when you're conveying property, the street address alone is not sufficient. This document is used to convey property from the seller to the buyer. So in addition to the address, we need to complete all applicable pieces of the legal description, what subdivision, deed book and page, tax pin ID, etc. Filling in the blanks. Then we have our purchase price. And let me make this a little smaller so we can see this whole thing here. We need to define what the purchase price is. So, oh dear, what in the world did I just do? Pay no attention to the man behind the curtain. What did I just do? Okay. So we have our purchase price. And the purchase price is defined in the following manners. This first line right here is going to be the agreed upon sales price. The buyer promises to give the seller X amount in exchange for their property. So let's say, for example, we've agreed to a purchase price of $100,000. The next line is for our due diligence fee, whatever amount we agree on. Made payable and delivered to the seller by the effective date. We'll define the effective date in just a second, but the contract tells us the due diligence fee is made payable and delivered to the seller. Whatever amount we agree on for the due diligence would go on this line. I'm just making numbers up. So we negotiate and we have $1,000 due diligence. The next two lines are earnest money. Maybe we have initial earnest money that's due at the time of contract formation or within 5 days of contract formation. And then we might have additional earnest money that is due later. Completely negotiable. Some buyers want to pay some of the earnest money now and some later. Some may agree to do all additional, some can agree to do all initial. There's no wrong answer here. It's all still earnest money. And it's all treated as if it was earnest money deposit. Let's say we agree to $1,000, just making numbers up, initial earnest money. You will note, that's a terrible line, our additional earnest money has a time being of the essence. What do we know about time being of the essence? When is this additional earnest money due? No later than 5 p.m. on this date. If it's not delivered by then, the seller could terminate. Question comes in, does the seller set the amounts for due diligence and earnest money? Both due diligence and earnest money are completely negotiable. Whatever the buyer is willing to offer and the seller is willing to accept. There is no set amount. There's no formula. There's no science. Whatever the buyer is willing to offer and the seller is willing to accept. Let me erase all that. Come down just a little bit. You have a loan assumption. If the buyer is going to assume the seller's loan, they're going to take over the seller's loan responsibilities. We will talk a little bit about that when we get into financing. If we're going to do seller financing, there might be a payment, a down payment. Seller financing means the buyer's paying the seller after closing. The seller's acting as the bank, as the lender. If it's new construction, there might be a building deposit. So what we're going to do with all these lines, what I was trying to do earlier, we have our purchase price of 100,000, my made up amount of 1,000 for due diligence, made up amount of 1,000 for earnest money. The top line minus all of these lines in between gives us the buyer's balance. We've agreed on 100,000. They've prepaid 2,000, 1,000 for due diligence and 1,000 for earnest money. What's left? How much does the buyer have to bring on closing day? $98,000. Everybody with me? It's credited back to them at closing. They've already paid that money once, so they're not going to have to pay it again. That's what we mean by that. It does go on to tell us that some or all of it may be paid with the proceeds of a new loan. So one way or another, this buyer's got to come up with the rest of the money for the seller, the $98,000. So we've defined our purchase price. We've defined our due diligence fee and our earnest money deposit. Page 2, we're still defining things. They tell us what the earnest money deposit is. It shall be deposited and held in escrow by the escrow agent until closing, at which time it will be credited to the buyer or until this contract is otherwise terminated. Once we get later in the contract, we're going to see these remedies, these breach of remedies. Yes, ma'am, Carrie?
I don't know if you've gone over this already or not, but is the commission fee included in that at the the 98,000 that they would have to bring into closing?
There's other fees, there's other debits that the buyer would have. So if they were going to pay our commission, then they'd have 98,000 plus. The buyer's always going to have to owe more than the purchase price because there's other fees, other debits that they have, closing costs, for example. So this is just how much the buyer's promising to give the seller. Okay, when we get into 21, we'll talk about other expenses and closing costs that the buyer has. Attorney's fees, for example. Okay, this is just the amount between buyer and seller. We need to, we need to identify who is the escrow agent, who's going to be the impartial third party to hold the earnest money deposit. Some real estate firms will act as the escrow agent. If you get licensed and you affiliate with a firm that has an escrow account, they will talk to you about how they expect their escrow account to be handled. A lot of real estate sales firms are doing away with the escrow account. We're letting the attorney deal with it. There's a lot of liability. We're going to talk about the escrow account, also known as the trust account, that comes in license law and commission rule. So we will talk more about that account. But here we need to identify who's going to hold the earnest money deposit. And then we have the effective date. The contract tells us that the effective date is the date that the last one signs, and such signing is communicated to the party making the offer. What's that magic moment in time when it goes from being an offer to a contract? The last offeree signs, and then communication of acceptance crosses the line, also known as the effective date. Most of the times this is going to all happen on the same day. But what if you're in the throes of negotiations at 11:45 p.m. and we sign at 11:50 p.m. and communication of acceptance happens at 12:05 a.m. Our effective date is the next date, right? We have to have both pieces. So our effective date identifies that magic moment in time. Can you guys see this? Okay. Here you go. There, is that better? Due diligence is defined as the buyer's opportunity to invest the property in the transaction contemplated by this contract, including but not necessarily limited to matters below, which we'll see, to decide whether the buyer, in their sole discretion, will proceed with or terminate the transaction. The buyer's due diligence period is the response to caveat emptor. Is it fair that the seller doesn't have to disclose? I guess it depends on who you're asking, right? Is it fair that the seller doesn't have to do any repairs? Again, it depends on who you're asking. How can we help the buyers get this time to investigate and learn about the property? We give them this due diligence period. Think of it as like a free look. The due diligence fee is a negotiated amount paid by the buyer to the seller for what? The buyer's right to terminate for any reason or no reason during the due diligence period. Why is the buyer paying the seller? So they can terminate. For what reason? Doesn't matter. They could have a big reason. They could have a home inspection report come back with a whole laundry list of problems. They decide they don't want to deal with it. But if they find another property, but if they have a change of heart, this is what this is, that free look period. There's a common misconception out there. So let me go ahead and squash this. Some people think that the due diligence period, the buyer's paying the seller to take their home off the market and not allow any more showings. That's not what this is about. Just because you're under contract, the seller can still have showings. The seller can accept other offers, or not accept, they can receive other offers. Just because we're under contract doesn't mean that the seller has to stop looking for a buyer. What they're paying the seller for is, everybody see this? The right to terminate. For what reason? Any reason or no reason, as long as they terminate within due diligence. Maybe the buyer shares with the seller why they're terminating. Maybe they don't. There's no requirement for them to tell them why. All they have to do is provide them in writing that they're exercising their right to terminate. The due diligence fee is the property of the seller. Upon the effective date, it shall be a credit to the buyer at closing. It is non-refundable except in breach by the seller. The rest of this is talking about paragraph 23, which is our remedy paragraph. So we will see that in just a second. What does it mean when the seller can't shop around? They can't shop offers. So you can't the agent can't pit buyers against each other. I can't call you and say, I got an offer in my hand for 100,000. Do you think your buyer can do better? We can't pit them together. We'll talk more about that. Yep, we're getting there. And then we have a place for the due diligence period, the period beginning on the effective date and extending through 5 p.m. on whatever date we put in here, time being of the essence. Our due diligence period is a drop dead date and time. The buyer has until 5 p.m. on whatever date we agree upon to terminate for no reason or any reason. If they terminate at 5:01 on this date for any reason, now they are in breach. I don't know what N means. Completely negotiable. When you guys see a blank, like for example, for the due diligence period, that's a negotiable point. What's one thing that would make a seller give a buyer more time? Let's say the buyer wants 4 weeks and the seller says, no, that's too much. I want to give you 2. What's one thing that might make the seller change their mind? You want more time? Give them more money. Isn't that what it's about? Time versus money. So that's why this is negotiable. If the buyer says, I want 4 weeks and the seller says, I'm only going to give you 2, maybe we can negotiate with some more money. Maybe we can offer some more money to the seller. You guys with me? All negotiable. Can the seller negotiate more than one offer at a time? Not really. We're going to talk about multiple offers in just a bit, so please bear with me. That's also in Unit 10. So we decide on the due diligence date, and then we need to decide on the settlement date. Settlement is defined as the proper execution, delivery to the closing attorney of all documents necessary to make this happen. The settlement date is a different date than the due diligence period. How long in between? Completely negotiable. Maybe it's a week, maybe it's 5. Completely negotiable between the parties. This is that period of time between due diligence ending and when we actually get to settlement. Delays in settlement are very common. Delays in settlement just happen. Because delays in settlement are common, you will note there is not a time is of the essence by the settlement date. The only time of the essence we have is with due diligence. We will see when we look at paragraph 12, we have a 7-day delay built into our contract because delays just happen. I recommend that you always look at your buyers and sellers and tell them when we go under contract to have a plan B. Everybody's going to work really, really, really hard to settle on this date. But in the event it gets delayed, what's your plan B? I get very, very nervous, like lose sleep kind of nervous, when my buyer says they have plans to show up at the attorney's office on that date in the U-Haul. Because I'm like, dang, what if something happens? Where are they going to go? What's your plan B? Y'all gonna sleep in the U-Haul that night if we have to delay closing? Always encourage them to have a plan B because delays in settlement just happen. Anybody ever buy new construction? Has anybody ever bought new construction? For those of your hands that went up, did you close on time? Did you close on the date? New construction is the biggest reason. There's a whole lot of outside factors involved in new construction, right? Hurricane Ian just came through. Did you guys see many builders out building when Hurricane Ian was through? Weather delays happen here recently. We're coming out as like supply shortages, labor shortages, all sorts of reasons. If you're not going new construction, maybe you don't have loan approval yet. So there's settlement, and then there's something called closing. Y'all want a confession? I have a confession to make. I've been in real estate this year. I celebrated 21 years. I have never in my entire life attended closing. You have never attended closing if you bought a house. You as an agent will never attend closing. We all call it closing. We refer to it as closing. Once you get your license, you will too. I need you guys to understand right now, there's a difference in settlement and closing. Settlement is what we attend with our clients. Settlement is when our clients go to the attorney's office and sit down and sign the paperwork. Settlement is when your buyers take whatever money they have to bring. Once we leave the attorney's office, once settlement is complete, then the attorney proceeds with what is officially closing. Closing is defined as the completion of the legal process, which results in the transfer of title to the property from the seller to the buyer. Closing consists of the following steps. It includes settlement that we defined above, the completion of a satisfactory title update by the attorney, the closing attorney's receipt to disperse all necessary funds, and the last act, the very last thing, is the attorney records the buyer's brand new deed. Then and only then is it a done deal. It's not a done deal until that new deed gets recorded. Remember, a deed of trust, just a fancy way of saying a mortgage. So if there's a lender involved, they'll record the deed of trust, the mortgage, on behalf of the lender. Buyers should not be getting keys or access to the property until that new deed is recorded. You and I are not going to get paid until that new deed is recorded. The seller won't get their proceeds. It's not a done deal until that new deed is recorded. Again, we all work really hard for settlement and closing to happen on the same day. We try really, really hard, but we need to understand that it's not a done deal until that new deed gets recorded. For example, a lot of attorneys won't schedule settlement after 3 p.m. So that way they have the buyers have time to come in and sign and do what they need to do. And they can still get that deed recorded at the Register of Deeds before they shut their doors at 5 o'clock on the dot. Y'all think the Register of Deeds is going to stay open later for you to record your new deed? No, no, no. 5:00 is when we close, right? So we want to have, and we can e-record, which means the attorney can send it electronically. Once we get confirmation of receipt, once we know that the Register of Deeds has received it, then it's a done deal. So let me ask you guys this. Can things happen between settlement and closing? Yeah. What if the attorney loses internet? What if Spectrum goes down and it's 4:55? They probably don't have time to hop in their car and drive to the Register of Deeds. You guys with me? So if the internet's down, what if the attorney's doing closing and they realize, oh no, I missed a signature from the buyer. Guys, they're not going to be able to go ahead and record and then get the buyer's signature. It's a done deal when that deed is recorded. So if your buyer, if they missed a signature, your buyer's got to come back. If the internet goes down, they won't be able to record. Always tell your people to have a plan B. Again, we're all going to work really hard to make this all happen on the same day. I promise. This is our objective, settlement and closing on the same day. As an agent, once it's recorded, you'll get my favorite email. You will get an email from the attorney that says, we are on record. That is when you celebrate. Many celebrations up until that point, but we are on record. What that tells you as a buyer's agent, you can give your buyer access to the property, give them keys, garage code or gate codes, garage door openers, whatever. And guess what that means for us when we are on record? Yeah, we get our money. I read that email, and what that tells me is I get to do a U-turn and go back to the attorney's office and get my firm's check. Woo! We don't get paid until it closes. And what's the last act of closing? Recording that new deed. There's a difference in settlement and closing. And I'm telling you guys, if you look at a buyer and say, we have settlement on this day, they have no idea what you're talking about. You look at a buyer and say, we're going to go to closing on this day, and they know what you're talking about. It won't take you guys long in the industry to start referring to everything as closing as well as the rest of us. Know now that there's a difference. Everybody with me? There's pre-licensing world, and then there's the real world. So in pre-licensing world, settlement and closing are two totally different things. We then define special assessments, either government special assessments or HOA, owners association. We're just defining special assessments right now, any charge against the property for the improvement of the property. So if it's a government special assessment, it might be to install street lighting or sidewalks, for example. If it's a special assessment by an HOA, then it might be to repave the parking lot, for example. Later, we're going to identify what each party's responsibility for the special assessment is. Again, you guys, I'm going to go back up just for 1 second. The first 2.5 pages of our 16-page contract is defining terms and definitions. If you guys don't do anything else, please look at these first 2.5 pages. Know what these things mean. What questions do I have so far? Okay. Second provision, we talk about fixtures and exclusions. Y'all remember the fixture conversation back in unit 2, I think. So we need to identify fixtures. Our contract, if you're using standard form 2T, the contract gives us a whole list of things that are going to be known as a fixture. If you're using a different contract, the fixture list may look differently. If you're using 2T, these are the things that are considered a fixture. Remember, we saw this very same list, exact same list in our listing agreement. So before we ever listed the property, we could have a conversation about the seller if they plan on taking their sentimental value mailbox. How are you going to replace it? What kind of mailbox are you going to leave? Is the buyer going to see it? Do we have to exclude it? We have all these conversations up front. So when the offer comes in, we know how to proceed. So any fixture that's not going to convey, other items that do not convey need to be identified here. Remember, you guys, if fixtures are meant to stay. If they're going to go, we need to identify them here. The contract tells us that the seller shall repair any damage caused by the removal of any excluded fixtures above. So when they rip the ceiling fan out of the ceiling, They need to repair that, replace it possibly, or the minimum repair that damage to the wall. And then after fixtures, we identify any personal property that's gonna stay. So as a refresher, way back in Unit 2, fixtures are meant to stay, personal property is meant to go. If they're going to do the opposite of their intent, we need to identify it in the contract. Fixtures are meant to stay, personal property is meant to go. If they're going to do the opposite of their intent, we need to identify them. When we are filling these out on behalf of our buyers and sellers, we need to be clear. Y'all just don't come in personal property and say, the refrigerator. What refrigerator? Is it the refrigerator in the kitchen or is it the drink refrigerator in the garage? Be specific. There have been stories about buyers purchasing a property, the deed changes hands, it's recorded. Now the buyer's the owner, and they go to their brand new house. And when they walk in the kitchen, what should be in place of the big refrigerator is like a 2-shelf dorm room fridge. Did the seller do what they were contractually obligated to do? If the contract says refrigerator, the seller can leave any old refrigerator they want, can't they? So let's be specific. 2-door stainless steel Whirlpool. If you can get the make and model number, sometimes when you open the doors, they're like on the inside panel. If you can get the make and model number. Listing agents and buyer's agents have a duty to make sure that any fixtures that are going to go and personal property is going to stay is in the contract. Remember we talked about the parole evidence rule? The parole evidence rule says no previous negotiations or advertisements matter if it doesn't make it to the final contract. The seller can tell you 20 times they're going to leave the refrigerator. But if we don't put it in the contract, they're not contractually obligated to do so. Then we look at the buyer's due diligence process. Their process starts with a big red warning. Buyer is strongly encouraged to conduct due diligence during the due diligence period. If the buyer is not satisfied with the results or the progress of their due diligence, the buyer should terminate prior to the expiration of the due diligence period, unless they can get a written extension from the seller. But keep in mind, the seller is not obligated to grant an extension. Can we ask for more time? Sure, we can ask. What's one thing that might make a seller agree to give you more time? Give them some more money. Money talks, right? But the seller's under no obligation to grant an extension. The buyer can continue to investigate the property after the due diligence period. The only thing they're giving up at the end of due diligence is their right to terminate. They can still keep inspecting and investigating. They've just lost their right to terminate. Then it goes on to talk about various things that the buyer should consider doing during their due diligence period. The loan process is the longest part of the contract to closing process. If a lender's involved, if the buyer's getting a loan, that's what takes the longest. We're going to talk about the loan. We're going to talk about the lender. That's where we go in units 14 and 15. 14 and 15 is our lender's units. Please note, there is no loan or appraisal contingency on this offer to purchase and contract. No contingency. Therefore, buyers advised to consult with their lender prior to signing this offer to make sure that the due diligence period allows sufficient time for the loan process. If we find out during the due diligence period that the buyer's not going to get loan approval and they can't come up with money somewhere else, then we terminate and we get them their earnest money back. If we find out after due diligence that the buyer's not going to get loan approval and they can't come up with money anywhere else, we terminate, and now the seller gets the earnest money. There is no loan contingency. In addition to the loan, the buyer is encouraged to investigate the property. You guys look at this. They can have various inspections done, home inspection, pest inspection. We'll talk, this is pretty much the list we're talking about when we get into unit 21, so we'll spend a little bit more time. If it's in an HOA, we want to get them a review of the documents, the covenants, and the bylaws. We want the buyer to have a copy of the Residential Property and Owners Association Disclosure Statement, the RPODs. We got to get the buyer shopping around for homeowners insurance. Again, we'll talk more about that process. Order an appraisal, have a survey, check zoning. Is the property in flood hazard? What are the utilities? Are the streets public or private? Any special assessments? I think it's important that we understand this list is just meant to give a buyer an idea of things that they should consider investigating during their due diligence. This list is not inclusive. So if your buyer says, can I investigate? Can I inspect something not on this list? Guys, please remember, if it's important to my buyer, it's important to me. So if they want to inspect it, do not look at them and say, nope, it's not on the list. We're not going to do it. If they want to inspect it, you look at them and say, okie doke. They are the ones that have to learn about this property, not me and you. So if it's important to them, then we assist them. That's why they hired us. Sale or lease of existing property. Again, this contract is not conditioned or contingent upon the buyer selling or closing or leasing another property. I have no built-in contingencies. Any contingencies they want, they have to add. Buyer acknowledges and understands. Here it is. Unless the parties agree otherwise, this property is being sold in its current condition. Isn't that just a fancy way of saying as is? The seller right there is telling the buyer acknowledges and understands that the property is being sold in its current condition. The seller may engage in negotiations for repairs and improvements, but they are not required to. If the seller agrees to do any repairs, those agreed upon repairs have to be in writing and signed prior to the expiration of the due diligence period. We have to have the seller's agreement in writing and signed to do any repairs before due diligence is up. Buyer's obligation to repair damage. Buyer shall at buyer's expense properly repair any damage to the property resulting from the activities of the buyer's agents, and contractors. So like we said earlier, if the buyer's home inspector damages the property, the buyer's on the hook for fixing it. The buyer can indemnify the seller You're indemnifying somebody, you're holding them harmless from all loss, damage claims. And then we have the buyer's right to terminate. Provided that the buyer has delivered any agreed upon due diligence fee, buyer shall have the right to terminate this contract for any reason or no reason. All they have to do is provide written notice by the end of their due diligence, time being as of the essence. If the buyer terminates, this contract shall be terminated and the earnest money shall be refunded to the buyer. If the buyer terminates while we are in due diligence, they will get their earnest money back. As a buyer's agent, worst case scenario, if you have to terminate, do so within due diligence. This is why we're helping them inspect and investigate and learn. Worst case scenario, we terminate within due diligence, at least I can still get their earnest money back. Closing shall constitute acceptance of the property in its then existing condition unless provision is otherwise made in writing. Congratulations, Mr. and Mrs. Buyer. The house and all its problems are now yours. Here are the keys. By this point, does the buyer know what the problems are? Do they know the existing condition? Do they know all the issues with the home? Hopefully, if they followed your advice and did their inspections and investigations. Once it's a done deal, guys, there are no takebacks. This isn't like a free 30-day return policy. Once that deed changes hands, it's a done deal, which is why our buyers have this opportunity to investigate and learn. So what if? What if they're not satisfied with the property in its existing condition? Let's say we have something called the final walkthrough. So the final walkthrough is something we're doing with our buyers on our way to settlement. We want the buyers to see the property's existing condition before they sign. Because once they sign accepting the property, it's theirs. So if we do the final walkthrough, maybe we had never seen this home vacant before. Maybe the seller had lived there until yesterday. And now we're seeing it vacant for the first time. And we start seeing the reason why there's pictures up. Maybe they were hiding holes in the wall. Maybe there's a bunch of trash left over. Maybe there's something that this buyer is not satisfied with in its existing condition. Your buyer pretty much has two choices. They either go to settlement and sign and accept the property as it is, or they don't. Are we going to request the seller to fix this stuff? Are we going to require? What are we going to do? That all depends. But what I need you guys to understand, once they sign, it's theirs. If they sign and they're not happy with it, they're accepting it as it is. Again, which is why the final walkthrough is so important. And it mentions it in here as well. Questions so far? Let's take our last break. We come back, we'll keep looking at our contract. I'll get that when we get back, Felicia. I'll answer that when we get back. Thank you. Absolutely. Okay. How we doing so far? I know this is a lot, guys. I know this is a lot. Are you going to revisit again? Are you going to go back and look at it again? I need you guys to understand. Once you get your license, this is you explaining the form and the contracts to your buyers and sellers. Because as I said earlier, they're not reading it. So if you don't have a conversation with them about due diligence and earnest money and how they can terminate and when, they don't know. Y'all, this is why they hire us. I know this isn't the most exciting part of the class. I feel like some of you are just bored to tears, and that concerns me because you're telling me you want a license to go work with buyers and sellers, but I can't keep your attention for 30 minutes, 45 minutes to talk about the contract, the legally binding contract that connects the two. Does that make sense?
Would you
What
say
better
this
day to start than today? Let's see. I see a hand and then I hear somebody. So I saw the hand first. Yes, Jeffrey.
Never mind. I'm sorry. I just answered it for myself.
Okay, good. And then I heard somebody unmute and I didn't catch who you were.
it's me? I'm
Excuse
just
me. Okay,
wondering,
Holly.
would you say this is like the most important piece, in your opinion, that you really have a grasp of, as opposed to like once you're in the real estate world, past the test?
In my opinion, this is the most important form that we use. In my opinion, this is the most important because this is the document that legally binds buyer and seller together. Guys, this is a legally binding contract. We're not out playing house. We're not out playing real estate. We are actually legally binding them. So in my opinion, yes, it is. When you guys take post-licensing, one of your post-licensing classes is contracts to closings. So we're basically doing unit 10 and unit 21. We're going to expand on them. And when you guys come see me in post-licensing, contracts and closings, we're going through this whole thing word for word. That's part of what we get to do in post-licensing. In pre, we need a basic understanding of it. In post, we're going through this sucker word for word. We're starting you today. We're introducing you to these things today. How you guys remember them and possibly answer test questions on the highlighted areas is you go back and review it. Remember your book. What do we say? Pages 287 to the top of page 293. A couple questions I see in the chat. Let me come back and address these. Right before break, does the buyer also get their earnest money back if closing? They don't get it back in the form of a check. It does come back to them as a credit. Remember, it offset the balance that they owe. So they don't get a check made out to them for that amount. So do they get it back physically? No, it comes back in the form of a credit, due diligence and earnest money. Let's see. Thank you for telling me you're back. Contract seems easier to understand than agency. Good. I'm interested to see what the test questions are going to look like through this unit though. Good, good. You got end of unit 10. We're not getting through unit 10 today, you guys. So you may want to hold off on unit 10 quizzes until we finish it on Thursday. I will finish it on Thursday. So we will wrap up. You may want to hold off. Test questions are how we truly identify if we understand it or not. So once we finish the unit, you got the questions in the end of the unit, you got learn, test, pass. You got the contract itself. Go over it again. I'm a big believer. Have you guys found a friend or a family member that's helping out yet? If you can take that contract and go through your very good friend or your very good family member and explain it to them so they understand it, you're in good shape. If you take that contract and you call your friend and you explain due diligence to them and they say, what did you just say? You need to go back and look at due diligence again, because eventually you're going to be the one explaining it to others. Does that make sense? So start now, see if we can't get the basics. Yes, repeat, We're getting contract better than agency. Good. So what should that tell you guys? I did not just say don't study contract, but I need you guys to also continue your study time on agency. Remember a couple weeks ago, I mentioned something about units 7, 8, 9, and 10. What are your heavily tested units? 7, 8, 9, and 10. What are those units? 2 of them are agency, 2 of them are contracts. You know what you're going to be doing out there in practice every day when you're working with buyers and sellers? Explaining agency and explaining contracts. Okay, so you guys are so hard on yourself sometimes. I saw this contract once and I don't understand it. I can never get it. Come on, guys, be easy on yourself. You just met this 20, 30 minutes ago, however long, I don't know, however long we've been at it. The way you get it is you revisit it, you go through it again. Where are my homeowners on this call again? I know I got a handful of you. Are you telling me you didn't sit down and read the contract when you bought your house? What? Did your agent explain it to you? And that's a rhetorical question. I don't want to know, but I hope they took the time to go through it, because that's our fiduciary duty. Everybody good with that? I've been really bad about this lately. Did I take attendance? No? Okay. I've been fine up until this class, and now I'm just not remembering to do that. So thank you guys for keeping me honest. Are we going? Yep, we'll talk about that on Thursday. Bear with me. I really wish I had a magic pill that I could give you guys and could give you all the information. You wouldn't even have to touch your book. All you have to do is take the pill and all the information from the book would go in your brain. I wish I had that to sell you. Truth is, if I had something like that, I would not be here in front of you today. I'd be out on the street somewhere selling my magic pill. Since I don't have a magic pill, I'm with you guys today, and we need you guys to study. We need you guys to get through this so we can get you through the tests. Fair enough? If anybody has any insight on how I can create that magic pill, no, I'm just kidding. There's no easy way out of this, is my point. Okay, so we looked at the 4th provision, which is all about the buyer's due diligence period. Now we're going to talk about the buyer representations. These are things that the buyer is telling the seller, representing to the seller. And the seller should be able to rely on this information when deciding if they want to enter into a contract with this buyer or not. So there's certain representations that the buyer has to make to the seller. And the first off is, how are they going to get the money to buy this house? So we have a couple options here. Is it going to be a cash buyer, or do they intend to get a loan? The buyer has to identify to the seller how they're going to come up with the money. If they are getting a loan, we're going to ask for specifics of the loan, such as, is it an FHA, VA, conventional? We'll talk about all of this in units 14 and 15. Is there going to be multiple mortgages, a second mortgage, other funds, etc.? But they got to share with the seller how they plan on coming up with the money to purchase. The buyer has to represent to the seller if they have to sell or lease another property. We're not creating a contingency. The buyer is simply letting the seller know, I do or do not have to sell or lease another property in order to qualify for another loan. If they do, then we're asked for information such as, for example, a copy of that contract. Prove to the seller that you have somebody under contract to buy your home. Provide them with a copy, for example. So we're representing to the seller, not creating a contingency. As a matter of fact, it says this contract is not conditioned upon the sale or the lease. If the parties agree to make this condition, an appropriate contingency addendum should be drafted by who? An attorney. So if we want to make the sale or lease of the buyer's property contingency, we have an attorney draft it up. Here's our RPODs and our MOG. The buyer has to represent to the seller that they've received it. Remember, they're signing acknowledging receipt. They're not signing that they like the way it was complete. The seller doesn't have to disclose. They can say no representation. But the buyer has to sign acknowledging receipt. And in our contract, they have to represent that they have received a copy of it or they have not. If they have not, then this could be a reason for the buyer to terminate. And if they terminate, this would be another reason why the seller would have to give back the due diligence fee. If the seller fails to provide the RPODs or the MOG within 3 calendar days of contract formation or receipt, that's another type of breach that the seller would have to give back the earnest money deposit. Same little exercise with the MOG. The buyer has received a signed copy. The buyer has not received a signed copy. And then we have buyer's obligations. These are the buyer's duties, the buyer's responsibilities, if you will. Buyer shall take title to all special assessments that may be approved following settlement. So if there's any proposed special assessments that aren't going to be approved until after settlement, those are going to be the responsibility of the buyer. The buyer is responsible for costs, any cost for them obtaining their loan, any charge by an owner's association for a transfer fee, appraisal, title search, title insurance, recording of the deed. Okay. Seller representation. There's things that the seller has to represent to the buyer. Remember, there's buyer representations to the seller. There's also seller's representations to the buyer. Again, the buyer should be able to rely on this information when trying to decide if they want to enter into a contract with this seller. So the seller is going to represent, first off, how long they've owned the property. Some lenders care about length of ownership, some don't. So the seller just has to represent how long they've owned it. Any property built prior to what year requires a lead-based paint? What's that magic year? Look, guess what? Once you get licensed, if you forget, they give it to you. We just got to get you through the test. So for your test, we need to know that magic year of 1978. Anything built prior to 1978 will include a lead-based paint hazard addendum. If there is an owner's association or an HOA, the seller is going to represent, they're going to provide the buyer, here's our covenants, rules and regulations, bylaws, parking restrictions. Again, you guys, the forms committee, they know what they're doing. This same list also showed up on our listing agreement. So we can have this conversation with the seller. If we're in an HOA, if we're in an owner's association, why don't you start gathering me this stuff? Because the contract says that the seller's going to provide them. So let's get them start working on these things now, if applicable. So it comes up again in our listing agreement. We see it here in our contract. What's the information of the HOA? What's the name of the HOA? What are the dues, X amount per month, per quarter, per year? And then the contact information, name, address, telephone number. We do have a place, some places have 2 HOAs, 1 or more. So we do have a place for multiple associations. If there's a fuel tank on the property, to the best of the seller's knowledge, there is or is not a fuel tank. If yes, let's get some information about it. It is currently in use or it's not. It's owned or leased. It's above ground, below ground. It's got oil, propane, gasoline, etc. So the seller is going to represent the condition of the fuel tank if there is one, or to the best of their knowledge. Seller's biggest obligation, the seller's duties to the buyer. Seller's biggest obligation is evidence of title. They're going to pay off any of their current liens in their non-foreign status. A non-foreign person is held under the Foreign Investment and Real Property Tax Act. I would consider getting an accountant involved if you're in this kind of situation. In the event that the seller can't provide that non-foreign status affidavit, they understand that there may be withholding from the IRS. So that's why that matters. That matters to the seller. You don't really need to know that. Access to the property. This is a good one. Seller shall provide reasonable access to the property through the earlier of closing or possession of buyer, including but not limited to the buyer's opportunity to conduct their due diligence, verify satisfactory completion of any negotiated repairs, and do their final walkthrough. Once we go under contract, the seller has to let the buyer in to conduct their inspections and investigations. The seller can't deny home inspectors, appraisers, all that good thing. Now, reasonable access, but the buyer has their right to conduct their inspections and investigations, and the seller shouldn't deny them access. The seller also has an obligation to provide existing utilities operating at seller's costs through settlement. So the seller needs to keep the power on, the water on in their name, so the buyer can do. It's kind of hard for the home inspector to inspect the water heater if the water and the power have been turned off. Yes. So the seller needs to keep those utilities in their name so we can conduct our inspections. Seller shall remove all personal property which is not part of the purchase and all garbage and debris from the property. Seller is going to provide an affidavit. An affidavit swearing that any person who has performed or furnished labor or services within 120 days prior to settlement have been paid. Y'all remember our mechanics lien? The seller has to sign something saying that a mechanic can't show up after the fact and put a lien on the property. So they sign an affidavit. Description of any lien agents. Seller shall execute and deliver a general warranty deed. You guys remember that from Unit 5, a general warranty deed in recordable form to convey fee simple, marketable, and insurable title without exception for mechanics liens, free from other liens, encumbrances. Every single thing in Unit 3 was an encumbrance that would be revealed by an accurate survey. Except this year's taxes, which we'll address in just a second, any utility easements, etc. Deed, taxes, and fees. Seller pays for the preparation of the deed. Again, when we get to Unit 21, we're going to break down seller costs and buyer's costs, debits and credits to each party. So we're going to see again there that the seller pays to have the deed prepared. And any other documents necessary to perform seller's obligation. Seller is responsible for excise tax. We talked about those back in Unit 5. We'll see those again. And then we have a place where it says the deed is to be paid to. Again, we're gonna list the names of all the buyers that are gonna show up on this new deed. Full legal names. The attorney is looking at this field to know who to make the new deed out to. If the seller agrees to pay any of the buyer's closing costs, how much? That's a negotiable amount. So the seller may be willing to pay X amount towards the buyer's closing costs. If not, we're either going to put NA or better yet in this field. Let's be clear. And how much are they going to pay? They're not going to pay any. $0. That's what we're seeing in this market. This will come back. Buyer's closing costs will come back. Seller pay closing costs. Here's our special assessments again. We said the buyer's responsible for any special assessments that's confirmed after settlement. The seller's going to be responsible for special assessments that are confirmed prior to settlement. So who pays these special assessments? It depends. If they've already been confirmed, the seller will pay them. If they're not going to be confirmed until after settlement, then the buyer will be responsible. Late listing penalties. If the seller didn't pay last year's taxes, 2021 taxes, they're responsible for paying those. Negotiated repairs. Contract says that these shall be made in good and workmanlike manner. Boy, that's kind of subjective, isn't it? Some people are better with a hammer than others. We'll just leave it at that. The buyer will always have the right to verify prior to settlement that they have been performed in a good and workmanlike manner. If you are the buyer's agent when you're asking for repairs, one thing you may want to consider is saying who you want to do the repairs. The repairs need to be done by a certified electrician or plumber, general contractor. If we don't specify, the seller can pull up a YouTube video, grab their hammer, have at it, think they know what they're doing. You guys don't have to be out there long before you see what we refer to as a handyman special. So not everything is done according to code. So again, that's very subjective. Is there going to be a home warranty? If so, who's going to pay for it? Completely negotiable. No home warranty. Buyer can obtain one that the seller will pay for, or the seller's already obtained one. So the conversation of the home warranty. And then we'll see paragraph 23 in just a second that talks about the seller's breach. I will answer that in just a second. Charges by owners association. Again, it kind of breaks down the seller's fees and the buyer's fees. This isn't in your syllabus yet because this was just added on July of this year. So they last revised our contract. In June, we were at 15 pages. They made a revision, and in July, now we're at 16. So thanks for that, Forms Committee. But they did address specifically owners association fees that the seller needs to pay, owners association fees that the buyer needs to pay. So they spelled that out. Prorations and adjustments, things, shared expenses. So back in Unit 3, we talked about taxes and how we're going to share that expense the year of closing. We'll see that again when we look at 21. We're also going to share expenses of HOA dues, rent, if any. We'll see prorations in 21. We will talk more about that then. Condition of property. If the property is not in substantially the same or better condition at closing, as on the date of this offer, reasonable wear and tear expected, the buyer may terminate this contract by written notice delivered to the seller, and the due diligence fee and the earnest money deposit shall be refunded to the buyer. So if the house is damaged by, I don't know, if it burns down while we're under contract, or if a tree falls on it and burns it down, a tree falls on it and tears it down, the buyer's not obligated to complete. They have a choice. They may terminate. If they don't terminate, if they elect not to terminate, the buyer's going to go on to closing. And in addition to the property, they're also going to receive any proceeds of the seller's insurance. So we're under contract and the house burns down. Guess what, folks? It ain't over yet. The buyer has a choice to make. They either terminate and get their earnest money due diligence back, or they purchase the property and they get the seller's proceeds of their insurance. If I were the buyer's agent and the house burned down when we were under contract, and my buyer looked at me and said, what should I do? I would advise them to call their attorney. I would also advise them to contact the seller's insurance company before they make a decision. I think we all know that insurance companies aren't known for their rapid payouts. So there may be some issues here that the buyer needs to consider. What we need to understand is the buyer has a choice. If the property burns down, for example, they have options. The risk of loss is going to be on the seller. The seller still owns the property until that deed changes hands, till that new deed is recorded. We got a whole unit dedicated to homeowners insurance. That's unit 13 that we will get to. We're going to talk more about this risk of loss. But we as listing agents need to have conversation with the sellers to not cancel their insurance until the new deed is recorded. Because if the house burns down while we're under contract, that risk of loss is still on the sellers. Here's our delay in settlement. As of July of last year, they changed it to 7 days. Your book has not updated yet. If you guys will look on page 292, your book still says 14 days. So I need you guys to update your book. The current contract says we have a 7-day delay. So this is what happens in the event of a delay. You have the parties. One is the delaying party. The other one is the non-delaying party. One party is responsible for the delay. Let's say, for example, the delaying party is the buyer because we don't have loan approval yet. So we're supposed to go to closing tomorrow. We don't have loan approval yet. We got to delay closing. What that means is the buyer has 7 days to try to get their loan approval so we can get to settlement and eventually to closing. The seller is stuck. The seller can't do anything for 7 days, but sit still and be patient and hope that this works out. Hope that we can get loan approval. If on day 8, we still haven't closed, now the seller could exercise their right to terminate if they wish. But they have to allow for that 7-day delay, the delaying or the non-delaying party. You guys see that on 292, where it talks about 14 days. Anytime you find old literature, again, this change is just a little over a year old. So anytime you find literature that says 14, just know that that's been changed to 7. So we have a 7-day delay. Possession of the property includes all means of access, such as keys, for example, and shall be delivered to the buyer when? Upon closing. Once that new deed is recorded, y'all, we should not be given buyers access until it has closed. A question comes in about loan approval. There's pre-approval. Pre-approval is no guarantee. Again, we will talk about, I'm getting a lot of questions about the loan. I got 2 whole units dedicated to the loan, which is where we're heading next. So 14 and 15. Pre-approval is not loan approval. Any addenda that we may add? If we have any others, we have identify attorney or party drafted addenda. We're going to talk briefly about some of these on Thursday when we look at our the rest of Unit 10. some of the more commonly used addenda. Here's another reminder for us. Real estate brokers are not permitted to draft. That's all you need to know. We cannot draft legally binding documents. May that be a contract, may that be a contingency agreement, may that be some kind of addenda. I cannot draft. Here's our assignment. The contract may not be assigned without written consent of all parties. So could we assign this offer to purchase and contract? Sure, as long as we have written consent of both parties. There's something called a tax deferred exchange. This is an IRS. What this does is it allows the investor, the flipper, to defer paying their taxes. So if they sell an investment property and use the proceeds of the sale of this investment property to purchase another investment property, they won't have to pay. They may not have to pay taxes. Section 1031. Thank you. I was still searching for that. IRS code 1031. If you are an investor or if you are an agent working with an investor, advise your client to talk to an attorney. Guys, I cannot give, not an attorney, the other A, their accountant. I cannot give tax advice unless you're accountant, unless you're up to date on the codes. This contract shall be binding upon and shall in order to the benefit of buyer and the seller, here it is, and their respective heirs. When do heirs kick in? When the individual passes away. Death is not an out once you're under contract. Entire agreement is saying that everything is one contract. Again, I kind of let you guys look through this kind of boilerplate stuff that you see in any contract formation. Okay, this is what I care about. Provision 23 is our remedy. So it spells out breach by the buyer, breach by the seller, breach by the buyer. In the event of a breach by this buyer, seller shall be entitled to earnest money deposit, the payment of the earnest money deposit, and the due diligence fee to the seller together serve as the seller's liquidated damages and are the seller's sole and exclusive remedy for the buyer's breach. So in the event of the buyer breach, what does the seller get? They'll keep the due diligence and they will get the earnest money. And that's it. Listing agents, make certain your sellers are good with those amounts. Ask your sellers, if the buyers terminate 1 hour before closing, what do you need? Because that's all they get. If the seller breaches and the buyer chooses to terminate because of the seller's breach, the buyer is going to get the earnest money and the due diligence together with reasonable costs actually incurred. There's our consequential damages in connection to the buyer's due diligence process, or elect not to terminate and seek the remedy of specific performance. So they can either go after the seller for the money, due diligence, earnest money, any money that they have spent in connection to this transaction, home inspection, appraisal, pest inspection, survey, or they can go after them for specific performance. The buyer could sue the seller to make them perform. Buyer signs on the left, seller signs on the right. Once we've come to all the terms, we need both parties to sign. This offer shall become a binding contract when on the effective date. So that magic moment in time when it goes from being an offer to a contract, once both parties sign and communication of acceptance. We do have a place for an entity buyer or an entity seller. So if it's a business buying or selling, we have a place there as well. Here's our wire fraud warning again. We saw this in both of our agency agreements. Again, you guys, email, sending wire transfer instructions via email is not recommended. Your emails are easily hacked. So what's been happening across the country is hackers get into my email, for example. And from my email, they send an email to the buyer or the seller and say, here's the attorney's wire transfer instructions. Send your money here. And if we don't have this conversation with buyers and sellers, they're running right to the bank with the hackers' bank information. And guys, once that money goes out, it's almost impossible to get back. So as their agent, probably one of the best things we can do to protect our clients is look them in the eyeball and say, I will never email you wire transfer instructions. If you get an email from me, it's fraudulent, I've been hacked, do not act on it. But they need to be aware, they need to know about this so we can prepare them for this. If they are going to wire their funds in or receive their money via wire funds, the suggestion is to go old school, pick up the phone and call the closing attorney at a number that you independently obtained and get the wire transfer instructions that way. Have them call. We don't need to be involved in this. And tell them not to call from a number that they get in an email. Because you know what hackers can do? They could send them an email and say, call this number with any questions. So have them go to Google and look the number up. Does this make sense? That's what we mean by independently obtain. So either you provide them the number face to face, not via email. Wire fraud in real estate got really big, really fast, as you can imagine. I mean, think about some of the dollar signs revolved around purchasing a home. North Carolina has not had a lawsuit yet that I know of. Other states have. And I'm telling you guys, when a buyer or seller lose their money to wire fraud, they're going after everybody involved. The closing attorney, the lender, me and you. They're going after everybody. So we need to do our part to make sure that they understand that I'm not emailing them this information. Other things we can do to protect our clients and their sensitive information. If you guys are going to go to Panera Bread one afternoon and work, be very careful about getting on Panera Bread's public Wi-Fi. Do y'all know who can access a public Wi-Fi? The public. So you go to Panera Bread and you start working and pulling up some of your client sensitive information, you may be subject to hackers getting in. If you have to work or if you choose to work in a public space, the suggestion is to go off of your mobile hotspot on your phone. Don't log on to the public Wi-Fi. The other thing when it comes to wire fraud, y'all stop using password 1234. Y'all, that's not a good password. Stop it. That's not a good password. Don't use common passwords. Don't use the same password over and over and over again. Sometimes your emails, like your Gmail, you can do a two-step verification. So when you log on to Gmail from a different device, not only do you have to have your password, but you have to have a code that you're going to get a text. That's another good measure you guys can take. And yeah, it's a pain in the butt because whenever you're doing it, inevitably your phone isn't with you, but it's an extra step that you can take to protect yourself and your client's sensitive information. So you guys just need to be very aware. You're getting your buyer's financial information. You might be getting social security numbers, full names, addresses, right? Anything that a hacker could need to do their job. So don't help hackers do their job. Make it hard for hackers. Fair enough? You guys just take these steps to protect your clients. Okay, notice information. How do we want to be contacted? We talked about this earlier. How do we want to be notified? If we want the buyers and the sellers information, we can list mailing address, fax number, email. A lot of agents I know do not complete this section. They put NA in because we want the agents communicating with each other, not buyer and seller communicating with each other. Your firm may have a policy on how to complete this information. So once you get with your firm, they'll offer you new agent training. And this is something that may come up if they have a policy. Typically for the contact information, we have the individual firm and agent's phone numbers. So the selling firm works for the buyer on the left. We have to identify if they're working as a buyer's agent, a seller's sub-agent, or a dual agent. We're going to list the firm's license number and address, and then the individual agent's information. If you're acting as a designated dual agent, you check that box. Our license number is required, 6-digit number once you get your license. And then our contact information. This is how we know how to communicate with the other side. We provide each other our contact information. The last page is acknowledgement of receipts of monies. Whenever money changes hands, we need to acknowledge receipt. So let's back up for just a second. We go under contract today. Yay, mini celebration. You call your buyers and you say, congratulations, your contract's been accepted, or your offer's been accepted. I need to meet you somewhere today to get a due diligence check and an earnest money check. So the buyer's agent's going to get those from their buyer. And then the buyer's agent is going to deliver the due diligence check to the listing agent. Once the listing agent receives it, they're going to sign, acknowledge, and receipt. Can we all agree that in your hand and on its way are two totally different things? Can we agree that's something different? Do you have it in your hand, or it'll be here by 3 o'clock? Guys, do not sign acknowledgement of receipt until it's in your hand. There have been cases reported to the commission where the due diligence goes MIA. And the commission starts investigating, and they see that the listing agent has signed acknowledging receipt. And they've called the listing agent and said, where is it? Well, I never got it. They said they were going to drop it off after lunch. So I just went ahead and signed it and left it at the front desk so they could pick it up. Who's going to be responsible for it if they've signed acknowledging receipt? The listing agent. So again, let's make sure we're all on board. In your hand and on its way are two totally different things. Don't you sign for it until you get it. Once the listing agent has it, then they're going to deliver it to their seller. In which case the seller is going to sign acknowledging receipt. We also have the escrow agents signing when they receive the initial earnest money and the additional earnest money, if any. So whomever the escrow agent is also going to sign acknowledging receipt. And that, ladies and gentlemen, is your now official 16 pages. 16 pages to say the buyer's going to buy and the seller's going to sell. Y'all want to hear something funny? I bought my little condo in 2006. So how long was that? 14 years ago? 14 years ago, the offer to purchase and contract was 8 pages. We doubled it in 14 years. Where are we going to be 5 years from now? Where are we going to be next year? It's so important that we stay current on these forms. Once they update forms, the North Carolina Association of Realtors will notify you. Your firm will probably have a special sales meeting just on the changes. If you don't know about changes, it's because you're choosing to hide your head in the sand and not be aware, is my point. When these forms update, when these forms change, we are notified, and our BIC discusses with us and hope that we're aware of the changes. So let's see. A couple questions I got. Does the buyer only purchase a home that is equivalent to what they are approved of? The short answer to that is yes. If the lender has said you're pre-approved for this amount, then that's how much the lender says they can afford. And it's based off of their debt to income ratio. So we'll talk more about that pre-approval process. You as a real estate agent, y'all please don't spend your time showing properties to buyers that they can't afford. You're only wasting your time and their time. So if the pre-approval, for example, says 200,000, don't show them anything over 200,000. You know they can't afford. Does that make sense? So we want this pre-approval very early because it protects not only me and them, but it saves us time, gas, mileage. I mean, could you imagine spending 6 months with a buyer and then finding out that they can't get approval, that they can't afford to buy a home? So some agents across the country have a very bad habit of showing buyers property without that pre-approval. In practice, before we throw them in our car or take them out and start showing them property, we want to make sure that they can afford to buy the home. We'll finish up, don't go anywhere, I'm not done, but when we finish up unit 10 on Thursday, and then we'll do our, how do you, for your state exam, how do I apply and that kind of thing. And then Thursday, we will start on unit 14. So I encourage you guys to, if you can, look ahead. 14 and 15 is where we're heading next. They are our lenders units. Let's see, a couple other units. So to sum up real estate, I'm loving this. It's researching the property, yes, and educating yourself to explain the property to the client. It also allows us as agents to educate and explain to the client about the agreements and disclosures and all legal matters. Hired attorney, and in all caps, she said, document everything. Protect your client at all costs. Isn't that the basis of OLCAR? Isn't that the basis of our fiduciary responsibility? It's my job to get you through the transaction. It's my job to help you navigate through the transaction. Once again, buyers and sellers are not reading this 16-page offer to purchase and contract. They're just not. That's why they hire us. That's why they have us to help them navigate through. I also think it's important that we remember we as agents are fact finders. I help my clients find the facts so they can make an informed decision. I'm not telling them what to do. I can offer my opinion, sure. But at the end of the day, what's my opinion matter, right? They're the ones buying this house. They're the ones selling this house. If the buyer is getting a home inspection and it runs past the date for the due diligence fee, the buyer cannot terminate. And that is correct. If we terminate for any reason after due diligence, now the buyer's in breach. They've lost their right to terminate. The seller will keep the due diligence, and now the seller will get the earnest money back, which is so important. Why we negotiate enough due diligence time to get the inspections done, to get the appraisal done, to help the buyer learn these things about the property so they can decide if they want to proceed or not. What other questions do I have? Question comes in about prepagent.com. That's another source that provides quizzes and study material. I don't have personal experience with prepagent.com, so I can't tell you if it's good or bad. Guys, you can go to Google and find all sorts of places to study. Just remember, if you find conflicting information, your book and the syllabus will prevail. I cannot validate everything that's on the internet. I just can't. So this is why we provide you guys stuff. I got a couple other resources that we will talk about on Thursday as well. But before you go out and start spending money, make sure you've gone through your book and learn, test, pass. Go through the things that have been included that you've already paid for. I'm trying to save your wallet here a little bit. Like I said, on Thursday, we'll talk about a couple other resources as well when we talk about our state specific section. How we feeling? It's good stuff, isn't it? All right. Thursday, when we come back together, we're going to finish up Unit 10. A few more things to talk about in there. Like I said, we'll do our real estate licensing, how you get your license, your application, state exam, all that good stuff. And then we get started on Unit 14. We go until 2 o'clock again this Thursday, last week, and then we go back to our normal 9 to 1. So today and then Thursday. I'm going to stick around and do some commission math. So if you guys want to hang out, you're welcome to. We're going to see what kind of questions we can do together. I will keep recording. So if you're not able to stay, you can always catch the recording later. Otherwise, that's all I have to say for today. I hope you guys have a great afternoon. Have a good day tomorrow, and give me 5 hours on Thursday as well. While we finish up talking about our contract and keep going. We keep going. There is no rear view mirror in this class. I was not kidding when I said that. So I hope you're finding your study time. You guys have a great afternoon. And
Thanks,
we'll
Miss
see you guys.
Julie.
Thanks, Julie.
Thank you.
Thank you.
Thank you, Julie.
Thank you.
Thank you, Julie.
Thank you.
You guys have a good day. Thank you.
Yeah.
Thank you. Girl, I got